welcome PIC, starting with the chairperson, Dr. Masondo, also a deputy minister responsible for PIC, and the executives from PIC, media and stakeholders who are in attendance. We are holding this meeting against a background where we had the engagement with the National Treasury and all the entities that report to National Treasury in preparation for the B-triple-R. So in engaging PIC, members raised certain questions which they wanted them, that those questions should be responded to in detail. At the time, PIC could not respond there on the spot. We agreed that we'll have another meeting where PIC will be able to explain or respond to the issues that were raised by members, and of which PIC has sent a report, should have sent the report on the 2nd. The chairperson, Dr. Masondo, wrote to me that there is still outstanding information, and I agreed to extend until the following day, which was the 3rd, because we didn't want a half-baked report. It took them long because some of the information is technical, and certain information is between the employer and the employee, and it depends how we handle such information. When they were about to send the report, I got a letter, correspondence from General Holomisa, raising questions. Initially, he had written to Scopa, and then he sent that letter to me. So we sent it to PIC that can you please attend to those issues raised by a member of parliament, Honorable Holomisa. So that's one other reason that PIC could not be able to submit the report on the 2nd, on the 3rd in time, because of the additional questions that Honorable Holomisa has raised. And in this platform, PIC will also attend to those questions. So you are all welcome. And then let's move to Dr. Beck. I see you raising your hand.
Yes, Chair. I need a point of clarity here, Chair. I'm sure members saw, and you've now mentioned, that the PIC sent us through a bunch of documents in line with our B-triple-R request. My concern is that the PIC want these documents to be regarded as confidential. However, my reading of the rules of the House of the National Assembly, and specifically Rule 189(1)(c), is that they can't do this unilaterally. I see that Advocate Jenkins is on the call today, and we as a committee would appreciate clarity on the issue of whether an institute can submit documents to us and then unilaterally declare them confidential. Chair, while Advocate Jenkins is answering this, I will also request that we've given the opportunity, given the gravity of what's going on, given that Scopa has handed this over to SCOF, given, as you said, General Holomisa's concerns, that we allow for a cross-examination style of questioning today, as opposed to a bundling of questions where the PIC then is able to perhaps skip over some. So if you will, given the time available to us, give us each an opportunity for perhaps 15 or 20 minutes to ask back and forth questions of the PIC, that would be appreciated.
Okay, Dr. Beck. We don't cross-examine here as politicians. We ask questions. If they don't respond, you have a follow-up question. So you will be given
a question, Chair.
Yeah, if you are not satisfied, second round, follow up. Second round, third round, so and so. Okay, there we are. Let's afford PIC an opportunity to brief the committee on the report that we have requested. Over to you, Dr. Masondo, and your colleagues from PIC.
No, thank you, Chair. The Chair of the Standing Committee on Finance.
Sorry, Chair. I've not gotten clarity from Advocate Jenkins on this unilateral declaration of confidentiality.
Meaning what? If it is written confidential?
They can't do that, Chair. The rules don't allow a submission to be labeled confidential by the submitter. I want Advocate Jenkins to guide us on whether he agrees that they simply can't do that, and when it's been submitted to this committee, it is no longer confidential.
No problem. Let's give him ample time. He will come back when Dr. Masondo finishes his presentation. He will respond to that request. Thank you.
No, thanks once more, Chair of the Standing Committee on Finance, Dr. Maswanganyi, honorable members, members of the public, and we really appreciate the opportunity once more to come back to account to the people of South Africa through Parliament on the work that we are doing. And Chair, notwithstanding the challenges from the old investments before our time, the PIC has performed well. If you look at the time when I started as a chair together with other board members at the end of 2021, the investment under PIC's management grew from 2 trillion rands, and it's now 3.6 trillion, judging by the figures we have in October. So this means that we have grown the investments by more than 1 trillion. And the unlisted portfolio, since its inception, has contributed significantly to job creation. The total number of direct jobs facilitated by PIC stood at 274,000 in 2025. And Chair, it's very clear that many of the issues that we are responding to today originate from old investments done a while ago, some 10 years ago, some 15 years ago. And it's very clear to me that the key issue is how we are exiting or solving these old bad investments in the manner that the PIC does not perpetuate wrongdoing and losing more money, and making sure that we don't repeat the same mistakes of our predecessors. And we really appreciate your questions, which we have responded in writing, and some of the suggestions on how to grow and protect the workers' investment. And we will, of course, not always agree on some matters of facts and some of the solutions that are being proposed by different South Africans. I mean, if you take the example of the unlisted portfolio, which is 4.5% of the PIC's total investment, there are those who argue that the unlisted portfolio should be closed or transferred somewhere, either to the IDC or DBSA, for instance. And I think this ignores, and this is also entailed in the letter that has been sent to you, Chair, and we'll respond in detail, but I think it's important for me at this stage to indicate that this proposal ignores 3 points. The first is that the proposal that says that the unlisted portfolio should go to IDC or DBSA, we must close, and so on and so on. This proposal ignores the fact that almost 1 billion rand is already allocated to DBSA and 8.5 billion is allocated to IDC. And we're already discussing with the DBSA on how best we should work together to deliver infrastructure. And secondly, the second argument on why the unlisted portfolio should be taken away from the PIC, it's that the credit loss ratio exceeds 39%, and therefore this reflects financial mismanagement within the PIC. I mean, just for the public, the credit loss ratio, it's a percentage of a loan that is not expected to be recovered or the lender is expected to lose. For example, 10 Rand of 100 Rand loan, if you lend 100 Rand, you expect to lose 10 Rand. So the credit ratio loss will be 10%. And put it mathematically, the denominator will represent the total outstanding loans, and the numerator is the portion of the loan that is lost, written off, or expected to be written off. And the credit loss ratio, it's also an indicator of asset quality or the quality of the debtors, their ability to pay back the money. Now, if you look at the transactions that have given us challenges insofar as impairment is concerned, the PIC's vintage analysis, that the year in which these transactions were done, confirms that 90% of impairments arise from transactions concluded between 2011 and 2017. This demonstrates the extent to which the current impairment and credit loss ratio are driven by historic transactions rather than recent investments. So we can safely say that the pre-party lending practices were not entirely prudent. And why? Then the question, the right question which has been asked in terms of the question that was sent to you, I mean, for us, it's important to frame the question as why the credit loss ratio is high within the PIC. I mean, firstly, as our written response show, and the CEO and the team will further elaborate on this ratio is high due to the legacy transactions. As I said, some of them date back as far as 2011, and some of them 2015. And Chair, in finance, it is understood that there will be unrecoverable parts of the loans that are written off after a careful consideration by the lender. And it doesn't mean that you plan for it, but that is for this reason that your credit risk assessment must be very robust so that you don't advance loans to assets that are poor, debtors that whose ability to pay back the money is quite poor. But generally, both the public and the private institutions do write off irrecoverable loans, but the PIC does not write off loans. And as a result, these loans remain in the loan books of the PIC, because our client does not apply any write-off policy or accounting standards that allows us to recognize that once a financial asset is no longer of future economic benefit, we can't write it off. And as a result, these old and defaulted loans continue to accrue punitive defaults, and each cycle of new interest is immediately impaired, which mechanically inflate the ratio, even when the underlying exposures are no longer recoverable. This accounting constraint makes the comparison to banks, lenders, and DFIs inappropriate in our view. And this is a point that we also think that the media reports are missing when they report about this particular issue. But like I said, we will get deeper. The team will further elaborate on this just to make the point that as long as you don't deal with this issue, the credit loss ratio will still be there. But and of course, Chair, we are making sure that like I said, our lending practices have improved. For instance, this quarterly monitoring of the portfolio and the proactive restructuring and paying closer attention to the management of maturing exposures. And we're also engaging our client on introducing a formal write-off policy to ensure transparency and alignment with local and global financial best practices. The second issue that this argument that we should do away with the unlisted or it should be transferred somewhere is the fact that this argument ignores that the unlisted portfolio, notwithstanding its challenges like Acapulco, Daybreak, and so on, the unlisted investment mandate has delivered a 16% internal rate of return, exceeding the benchmark set by the client, which, for example, 100 billion investment will generate 16 billion for the worker. So it is performing, it has its own challenges, but it is doing, by and large, better in terms of its performance. And like I said, many of these bad investments, they are prime party investment, and we're doing our best to sort out all the challenges and strengthening our capability to protect workers' money and improve and increase their wealth. On the issue on Acapulco, Chair, as we've said previously, that we are not happy with the outcome of the arbitration, mainly in relation to the valuation. And when we met last time, we only had one legal opinion from SC that advised that the prospects for success on the review or appeal of the arbitration are slim. And we indicated that we are in the process of getting a second opinion, and indeed, we have since obtained or received the second legal opinion, which states that the chances for our success in appealing against this arbitration award are very slim. And as a result, the board has heeded the advice of the senior legal counsels because we don't want to engage in frivolous litigation, which the law is very clear if you engage on those actions. So, but the team, again, the CEO and the team will further speak on this, on what are the next steps that we are undertaking internally, but also externally to deal with this issue, short of going to courts to seek a review and appeal of the arbitration award, given the fact that the two senior legal counsels, they indicated that the prospects for success are limited, and therefore if we are to undertake such frivolous or potentially which can be deemed as frivolous legal actions, we may be found wanting as the PIC in relation to yourself, but also society as a whole. Chair, we have sent you a very detailed responses to the questions that we've sent to us. And we did mark the responses as confidential, not because we want to hide anything from anyone, There is some information that we think that it is sensitive, that if we make it public, our ability to recover money, the money that all of us, we have a responsibility to protect and grow, it may be difficult. For instance, if we show that, as we have shown in the list, that on this loan, there's a potential, there's a possibility that we may not recover the money, but we are still pursuing those people. Now, if you come here and say, no, this is what we are doing, whoever we are chasing, we are going after, might say, look, you've said publicly that you're not recovering this money. Why are you following me? So it's not an attempt to hide anything from the committee. We will want to be radically transparent and just to show as much as possible, but at the same time, do it in such a manner that is responsible, because at the end of the day, we're acting in the interest of the workers, we're acting in the interest of good South Africans, and we don't want to reveal information which will be in the hands of people who have done wrong to the PIC, and they use our actions in such a manner that it defeat the purpose of us doing good, because our understanding is that even coming here to account and explaining whatever we're accounting for, it is in the interest of South Africans. It's not to hide anything. But if the committee members feel that they are willing to risk us enabling basically people who have done wrong to the PIC, to the clients, will go scot-free. We need to take responsibility if we think that that's the best approach in handling some of the issues that we have shared with you in confidence. And we didn't want to hide anything to Parliament, because we do believe that Parliament is honorable precisely because, amongst other things, we do assess what's in the interest of the South African citizens, something that should enable us to catch people who are doing wrong against the workers. But look, this is a question of judgment. If our judgment is wrong, let's see how these things unfold going forward. But we don't want to be held accountable for being reckless and enabling those who have done wrong, continue to do wrong in the PIC, to go scot-free. There are forensic reports that we've already shared with the police, and in the report that we've shared with you, we've shared the case numbers. And if honorable members want to follow those forensic reports with the relevant institutions that are dealing with these matters, SIU, the Hawks, and so on, you are at liberty to do so. But we don't want to take functions that do not belong to us. As the PIC, where there's criminality, where we see wrongdoing, we report to the relevant authorities. And if the committee, given its responsibilities and within the law, you are at liberty to do what is appropriate. But we will not want ourselves and this committee to also undermine the ongoing investigation and undermine our ability to recover the money that and hold people accountable through the institutions that this Parliament has established through its laws. And Chair, there are legal and HR matters and some of the decisions that the CEO has to deal with, and I'm sure he will speak at length about those issues insofar as HR matters. But we have in detail shared with you those issues, HR matters, transaction matters, and so on and so on. So at this stage, Chair, if you may allow me to ask the CEO to take the committee through to add in relation to some of the questions that you've posed, and he's got his own team, and he will advise on how some of these questions need to be answered. CEO, over to you.
Thank you very much, Chair. And
Order, Chair.
Okay.
Dr. Beth?
Chairperson, I'm sorry to interrupt the proceedings. The PIC and its chairperson and presumably its CEO seem to be operating from the assumption that they can't talk about the details of the documents shared with us yesterday. And for this to be a constructive session, it's my contention that we please now need Advocate Jenkins to inform us whether this contention of the PIC is correct.
Dr. Beck, you requested that in the beginning, and I told you that let's give Advocate Jenkins time and space to work on that advice to the committee.
And he's had half an hour, Chair. Could he please guide me?
Don't do that, please. Respect the chair.
I'm very respectful of you, Chair. The point is we need a legal answer here, and if we wait for 3 hours, then it's no use getting the answer.
No, don't do that, please. Don't do that. We don't ambush our people who are supposed to assist us. He must work on it, and then if he has to consult colleagues in the legal division, he will do so. Before we leave here, there will be clarity.
We're going to have clarity when we leave here, Chair. It's too late. I've sent a message to the Secretary an hour before the meeting. Advocate Jenkins to the call. Can he give us an indication of whether he feels ambushed at the moment?
You are not the chair of this committee. You are a member. This committee is chaired, and I've told you what we are going to do. Let's call the CEO and the team to proceed with the presentation. You will get that advice from Advocate Jenkins and his colleagues before we leave this meeting, please. CEO and your colleagues, please proceed.
Thank you, Dr. Mazong.
Honorable Wekelin, wait, CEO. Let me listen to Member Wekelin.
Good morning, Chair. Thank you very much. I just want on record that I am the alternate member for finance, and I'm standing in for Honourable Member Wendy. She is writing exams. Chair, can I just get an indication from you as Chair, if we are going to get the answer at the end, how do you suggest we proceed with our questioning with regards to the presentation that will be presented to us, and without infringing on any rights? So we need clear clarity, Chair, because we've got a very specific set of questions, and I'm not sure if we could ask them, and that if that comes after the fact, it will has an impact on the way we're going to proceed. Can you please just clarify? Thank you, Chair.
Thanks, Honourable Wekelin. The advice will not come at the end of the meeting. I requested Advocate Jenkins to work on advising. By the time we take questions for clarity and comments, I hope Advocate Jenkins will be done with that. I want him to do quality work. Just to tell a person that here's a problem, give us an advice here. It does not work like that. He's a professional. He has to follow a particular methodology of making sure that the opinion that he gives us stand the test of time. Let's allow him to do that. By the time we go to questions and comments, the Advocate Jenkins will be ready.
Thank you, Chair. I concede. It's just that we also obviously accept that we will get the professional opinion as soon as possible. Thank you, Chair.
Yes, we want to get a professional opinion, not something that is half-baked. Hence, we must allow people who give us opinions and advice in space and time to work on the advice that we are seeking. Thanks. Let's allow the CEO and his team to proceed with the presentation.
Thank you, Honourable Chair, and good morning to the members of the committee and the public and the members of the media. We sincerely appreciate the opportunity to further give clarity on the number of issues as raised in our last engagement with the committee chair. And really, as the chair said, we really want to make sure that the committee is fully satisfied that as the Public Investment Corporation, we are doing our utmost best to make sure that we deliver on the expectations of our clients and that we make sure that we safeguard the investments of the beneficiaries of our clients. And in that, we are busy making sure that all our systems and the governance are really optimized. And this is something that we continuously work on, Chair, and we keep our clients posted on our progress. And we will definitely make sure that we are always available for the committee, to make sure that we address any of their questions and concerns insofar as our investment decisions and our deals are concerned, Chair. I wanted to touch, after the chair of the board has taken you on a number of issues, I wanted to start off with the people issues, Chair, if you will. Allow me to, that there were a number of issues that concerned some of the current staff members as well as the previous staff members. Starting with Mr. Vianney Hako, who we entered into a mutual separation agreement. And as a result, the committee members were asking how this happened. We have submitted our report to this effect, Chair. And I think what is key to highlight is that on the 30th of July 2024, the board resolved to task the CEO, my predecessor, to engage with Mr. Yako to look at the potential mutual separation settlement. And indeed, it happened, and eventually the final settlement happened, and the maximum, and if we were to look at this, Mr. Chair, the agreement was concluded on the 19th of August 2024, wherein the final settlement of 10,418,107.35 was then 16 days of accrued leave of 367,960 rand and 88 cents was entered into. I think it's important to highlight to the committee as well, Chair, that a very strict confidentiality undertaking was entered into by both parties in regard to the separation. And as a result, we are not at liberty to share the content thereof, Chair, but I think suffice to say that it was eventually entered into, and those amounts that I read out, just over 10 million was agreed as a final settlement by both parties. And the second one, Chair, is the suspension of our acting head of unlisted investments, Mr. Thabiso Mushikara, who is on suspension after the allegation that were made by one of our investee company sponsor. And in this case, we have since received our final report from independent investigator to this regard, and the whistleblower eventually shared the information. I must say that we are now looking into this report, and we should be able to finalize our way forward with Mr. Mushikara in the very near future, Chair, in this regard. And then the second one, Chair, is the issue of our company secretary and the reinstatement of our company secretary. And on this regard, Chair, I must say that the previous board took a decision not to go ahead with the dismissal, but instead chose to give a final written warning for 12 months to the company secretary. And indeed, that was done. And the final written warning endured for 12 months. And now we're beyond that period, Chair. And this matter, I must highlight, Chair, that it has proven to be quite a painful matter to our staff member. In that it's an issue that is looked at. The board has also tasked us to look at how we can be able to finalize it further. So we are looking at it and we are taking legal advice on how best we can deal with it going forward. So it is a matter that is still under further investigation or further review, as the board in the recent past, I think a week or 2 weeks ago, it was a week ago, wherein I was asked to relook into the matter and conclude and report back to the board in this regard, Chair. So that it's a matter that is still underway, and I will report to the board, and I'm sure eventually we will have to also appraise the committee on how we finally decided on the matter. And I think the other one, Chair, was an issue of our CIO, who's also on precautionary leave. And this matter is still being dealt with between both ourselves and the lawyers representing our CIO. And in this week alone, actually, we had no less than 3 face-to-face engagement with the CEO, where we're dealing with some of the specific issues. And we are still dealing with this matter, but we are hoping that we'll be able to reach some sort of finality in a not too distant future. But it's a matter that we are currently deal with, Chair and the committee. Then there was an also issue of the vacancy of the head of listed investments, wherein it was asked that certain candidates were friends or known to our CIO, who's on suspension, and we were advised that in so far as that is concerned, Chair, the CIO did declare knowing some of the candidates in the meeting and before the interviews. So it's a matter that is quite low within the system, Chair. So, but the position still has not been filled at this point in time. I can then go on to the issues of material irregularities, Chair. As per the AG, we did share with the committee last time that Enabled Capital, the AG, is satisfied with how we've dealt with the matter, and now they are still considering the daybreak matter. And again, I'm quite positive, Chair, that with the progress and the registration of the bond in favor of GEPF for their 250 million rand is underway, and we are hoping that very early in the new year that matter should be finally registered accordingly. And on the Lanceria matter, the Chair wanted length, Chair, in terms of the Acapulco. Yes, Chair, the 2 senior counsels did advise us that it's the matter that we have very limited success on, and we cannot continue on taking it on review. And the board has also concluded that we then we have now appointed an independent reviewer to look into where we might have dropped the ball, and we will then be able to act accordingly as soon as that report is finalized, Chair. In this regard, Chair, I know that there was also the Levoca matter, wherein we were asked various number of questions, but as far as the plaintiff matters are concerned, these are matters that actually are more with GEPF than with PIC. So they are not with us at all, and we are not able to deal with, as the general was asking questions here, as the GEPF will be best positioned to deal with those matters. But in so far, our senior employees were implicated in the Levoca matter. I have taken the committee through the Mushikara matter, that we are looking at that matter. But insofar as the other staff, we could not find any further evidence in this regard. And also the police said they could not find anything else actually that implicates our employees in this regard. So we consider that matter is now closed as far as we are concerned, Chair. And I'm trying to see what other matters, insofar as the matter of enable capital, we've touched on it, yes. And yeah, I think Chair, the issue of our Isibaya and unlisted investments is a matter that we have looked at. As the chair said, that this matter dates back almost more than 8 years ago, and we only had one enabled capital that happened recently. And the enabled capital, the way we looked at it, Chair, was that it was just a fraud matter where we were defrauded, both ourselves as well as some of our private players in this regard. So we have reported this matter to the law enforcement agencies, and we regularly meet with the law enforcement agencies to see how they are progressing, and that's how we are dealing with this matter. But at least the good thing was we were able to pick up before we could make the second tranche of 100 million rand disbursements to them. And I think there was another matter in terms of the forensic reports. We have shared with the committee these reports with the chair, and yes, these issues do have some level of confidentiality in them, but insofar as all the allegations of criminality are concerned, wherein certain individuals, in terms of the daybreak, we have again reported the matter to the law enforcement agencies. The BRP has also reported the matter to the law enforcement agencies, and as such, we then follow up on the progress there too. But again, we want to make it very clear, Chair, that the daybreak matter is the matter that we do believe has a very good chance of saving the jobs and being able actually to pay back all the funding actually that has been extended to it, or just about all the funding, because it is going through a strategic equity partner, is also being finalized. I think we're waiting final offers by the 12th of December. And we have also pledged 300 million rand to enable the reactivation phase, wherein at least the current 500 employees who are working on the breeding as well as hatchery can be looked after, as well as the reactivation of the Sundra abattoir, which will be able to get back into full employment close to 1,000 employees. In total, we'll have between 1,300 to 1,500 employees that will be able to gainfully re-employed pending the reactivation of the Delmas abattoir. So we have the teams working flat out to make sure that Daybreak is able to become eventually fully operational, and we are hoping that we'll be able also to secure the strategic equity partner we must say, Chair, that the interest was quite interesting from the people who were looking at this, and they were pleasantly surprised to see the current operation, albeit at 40% of the hatchery capacity. But it is something that actually is coming up quite positively. We're seeing very interesting green shoots as far as the daybreak matter is concerned. And we are hoping that it will never take us back to its past and rather focus on becoming a sustainable and optimally run with optimal levels of governance to make sure that we secure and sustain the employment and the livelihoods of those associated with it, Chair, as well as filling the gap in the poultry market in South Africa. We have given the committee the party report, the recommendations, and the implementations, wherein we do indicate whether we have fully implemented these recommendations or not, Chair. We will be willing to take questions there too, but it is quite a comprehensive report, Chair, that we have made available to the committee, and we will continue to engage and take questions in this regard. We've also annexed a number of documents as well that gives more information in terms of the valuations and the methodology of the valuation methodology and the value of these assets and their value as at the end of March. We have made those available to the committees, as well as the list of the indirectly held properties as well, Chair. We are happy, Chair, to take questions and comments from the committee members in this regard. I thank you very much, Honorable Chair and members.
Yeah, thanks, Chair. That's our report. And just one last point. We're really looking forward to hosting you at the PIC and taking you to different places, assets in which we have invested. The team is working, Chair, to put together a program, an itinerary that will guide your visit. And of course, we will finalize that itinerary with yourself. So the team is also working on that itinerary for your site visit. Thank you very much.
Thank you, Dr. Masondo, the CEO and the team from PIC. Let me check Advocate Jenkins as to how far is he working on advising us on the matter that we requested him to attend to. Advocate, are you there?
I'm here, Honourable Chairperson. Good morning, honourable members. I have had the opportunity, thank you for that, to consult my office. I've also looked at various pieces of legislation as well as the letter to the chairperson. So, Chair, I can give advice on this matter, and if there are further questions, of course, one can come back and deal with those. But if it's sufficient, then good. So, if it's in order with you, I can quickly brief the committee on what my view is, or the legal view on this request, Chairperson. So, I think firstly, the classification of the correspondence to the committee. There's two ways where that can happen, which has an effect in law. One is, of course, if it is allowed in legislation. If it's submitted in terms of legislation, which of course will be a problem, because it would not be allowed to be submitted to Parliament if it was classified, unless it's allowed in that legislation. And one thinks here of what is happening presently with intelligence information relating to security services must go to the Joint Standing Committee on Intelligence. And the second area where such thing can happen is for instance, records of SARS, South African Revenue Service, which only certain bodies may disclose, for instance, to the FIC, Reserve Bank, and so forth. Even those records may not be disclosed to Parliament. So, Chair, the answer to the question, can a public body who submits documents to Parliament for oversight, as in this instance, can they unilaterally classify such documents? Only if it's allowed in legislation. And in this instance, I don't see that provision in the PIC Act when they report to Parliament. So I think it's more of a request to the committee, if one can look at it like that. They don't have to have the statutory power to classify such documents. So, Chair, the rules of the National Assembly would then allow to, upon such a request, for the committee to consider such a request by either closing the meeting, going through the documents and see whether the meeting should be closed, and then opening the meeting itself. And if the committee feels it should be closed, then of course it needs to be a justifiable closure of that meeting. In this regard, Chair, so we now, where the committee wants to decide and they close the meeting, to consider it. The committee's consideration whether to close a meeting is guided by the Constitution first and foremost, which indicates that committee meetings must be open and accessible to the public, unless it's closed or the public is prevented from attending because it's reasonable and justifiable in an open and democratic society. So that is the core test, whether a meeting can be closed, or what the Constitution calls excluding the public and the media from attending. So, Chair, the NA rules have tried to give guidance on that matter, and the NA rules have come up with, in Rule 184, it indicates that there's certain areas where a committee can be closed. Let me just get that provision, Chairperson. Sorry, I was on another matter there. But one of it is if it's closed in terms of legislation, which we've dealt with. So that is not a matter. The second issue, if it is a private nature and it's prejudicial to a certain person, and this also does not feature here because we're dealing with public information. We're dealing with a matter or actions taken by an entity, by a public entity funded by taxpayers' money. So it's not a private matter. This matter is also not protected under parliamentary privilege or confidential in terms of legislation which I've dealt with. So the examples given in NA Rule 184 to give some flesh to the constitutional provision of what's reasonable in an open and democratic society does not assist the PIC in this matter, Chairperson. That is my view. So I formulated that view. I've discussed it with a colleague who agrees with me and also indicated that there are certain documents that has been handed to Portfolio Committee on Public Service and so forth that also contains various information of a public nature and then details of certain persons who are working with or was involved with working with government departments. So, Chairperson, there are examples where what I would call employee-related issues, as it's stated in the letter, have been discussed in Parliament. In fact, Chair, if one can go to legislation, when we're looking at the protection of access, the promotion of access to Information Act, or what we call PIC, we look at Section 34 there now. The Promotion of Access to Information Act is there, so it allows people to access information, and then gives certain scenarios where information may legitimately either be withheld permanently or where you have to get third-party notification and so forth. And the Act clearly states in Section 34 that the information about an individual who is or was an official of a public body and that relates to his position or his functions, including but not limited, so it's an open list, whether that person was an official, the title, the work address, work phone number, salary scale, remuneration, responsibilities of that person. I'm just listing these, Chair. None of these will be regarded as private. All of this is public information, and even members of the public may request this information from a public body. Chair, if we turn to the Protection of Personal Information Act, in Section 4 of that Act, Chair, it states clearly that the Act must not be interpreted to prevent a public body like Parliament from exercising and performing its powers, duties, and functions. And we recently had a court case on this matter where and perhaps you're aware of this, where Parliament made a recommendation for the appointment of commissioners of the Commission on Gender Equality, and their CVs were regarded as private, and we only gave redacted versions, very short versions of those. And the litigant was successful in court because the court said such CVs, either it should have been redacted, which is not relevant for the position, for instance, ID numbers and so forth, but insofar as Parliament needs to disclose this information, it is a public exercise, and you can't use that to say, well, you can't do your function to do, whether it's the appointment of commissioners or I would even argue an oversight matter. You can't use that. So, Chair, where are we going with this? My view is that the committee can decide, not PIC, whether to close the meeting or not. When the committee decides, it must be guided by the constitutional provision, what is reasonable and justifiable in an open and democratic society. And in trying to, in reaching that conclusion, I would advise the committee looking at the Promotion of Access to Information Act, looking at the so-called POPI Act, the Protection of Personal Information Act, that there is a strong, if not an overwhelming weight of statutory provisions that says that when Parliament is busy with its oversight function and it's requesting information, that is public information. And in exceptional circumstances, one can close that. Now, Chair, the PIC, with respect, have mentioned two things in the letters: employee-related issues, specific transaction details, and then during the presentation now it says that if Parliament is, and I'm just not paraphrasing, using my own words here, if Parliament is prepared to jeopardize the chances to recover these monies by disclosing this information, then Parliament must take that risk. Now, Chair, I'm not going to classify this statement. I'm just going to say that it's a strange argument. Maybe the PIC needs to elaborate on it. But if someone is falling foul of the law or falling foul of a policy of the PIC and needs to be disciplined, and that disciplinary inquiry can be jeopardized by making certain information public, they need to explain that, because my view, Chair, and it comes way back to the 1700s, when we were looking for someone, we used to put up a poster saying wanted. There's no secret who we want to catch. It might even assist other people who might wanting to employ this person as a audit executive or something, if we don't know this information that there is an investigation ongoing. Chair, a person always has his or her own rights to protect themselves from victimization, from malicious prosecution, and so on. So I think the principles of acting in good faith and the constitutional principle of openness and transparency is something that needs to guide this committee. So, Chair, in conclusion, I do not, at this point in time, see the statutory requirement for this meeting to be closed. So the committee is free to decide whether to close it or not, given the information before it and considering the advice I just formulated for it, Chair. So that's my view on this. Thank you very much.
Thank you, Advocate Jenkins, for that assistance. Okay, before I proceed, let me take Honorable Van Rooyen.
Thank you, Chair. Just a clarity. Good morning, Chair, and of course, good morning to all in attendance. Just a clarity from the Advocate. We are as a committee, we are not faced with this matter for the first time. I think recently we dealt with a matter similar to this one. I think what is really concerning to me is this process of classification, because the submissive entities and departments are not clear on the process of classifying documents. Is there no clear process that they should follow in advance before we get into a meeting? Because the truth of the matter, this meeting is a public meeting as we speak, and they seem to have requested certain things not to be entertained in a public platform. So it's immersive. There's no clarity between departments and entities as to which process should they follow before they classify documents, Because if you classify a document but you subject it to a public meeting like this one, what is the use, So I just want to check with the advocate. Is there any clear process that is defined to department and entities on the classification of documents? Because the law is very clear on the process that should be followed in terms of the committee determining if the meeting should be closed or open. But this one of people submitting documents and classifying them, I don't think there's clarity around that. So I will request some clarity from the advocate on that matter. Thank you, Chair.
Thanks, Honorable Van Rooyen. Advocate Jenkins.
Thank you, Honorable Chair. Honorable Van Rooyen, thank you for the question. I would say the two examples which I can think of. One, if an entity comes to Parliament and says there was an investigation done, forensic investigation, but there's an agreement with the body who did that forensic investigation that the report is confidential and it's only limited disclosure. In that instance, if that report is serving before a committee, the committee should consider that because there's a contractual obligation and consider the implications. But usually, the law will prevail. So Parliament's oversight responsibilities will prevail over that matter. But certainly, if that would result in the investigation being terminated or something like that, one needs to take it into account. But it's a very grey area that Honourable Van Rooyen is. The second area which I think departments or constitutional institutions or public entities need to follow is to take information that they want to classify to their executive authority, their minister, in other words, to take it to cabinet and through the MIS document, the Minimum Information Security Standards document, to classify it through that. That is the document that is being used at the moment to classify. There's also Protection of State Information Act and so on, which can do classifications in terms of that act. That's the old act from the 1980s. I think the new one has not been finalized. So those are the avenues that deals with legal classification of documents. Thank you, Chair.
Thanks, Advocate. Thank you very much for that advice. I will call upon members to find time, look at, as Advocate has assisted us, Rule 1.4. It talks about the admission of the public into committees or business of Parliament. It outlines the procedure that has to be followed, as Advocate Jenkins has alluded to, and that permission or that decision is taken by the Speaker, because subsection 4 of 184 outline or define the powers of the Speaker to take that decision. It says the Speaker may take reasonable measures, and then ABC outline those measures. Amongst other issues that we have to attend to, I spoke to Alan that he should invite Honorable Nkwankwa to come to this meeting, because the leader of his party, General Olumisa, has raised the issues. So it will be important that a member of that party concerned should come here and engage with the report, because the issues that were raised by General Olumisa, Deputy Minister, will be ventilated by PIC in their report. So Section 185 speak to the presence of other assembly members, meaning that any member of the National Assembly can attend any meeting, probably with the exception of the one that's dealing with the state security and others. But he does not have the voting rights. So he has the speaking rights. So let me clarify that when you see Honorable Kwankwa here. And then you go on section 186, outline how you exclude members of the public from the meetings and excluding other persons from the meetings, removal, publication. In regard to the documents that have to be not published, if you look at Rule 189, subsection 4, it outlines the rules that apply to such documents. It is A, B, C, D. So in getting the advice and looking at the rules here of the National Assembly, this meeting is open to the public. We have been applied to the Speaker that it should not be open. Hence, the information presented here cannot be classified as a secret or very confidential to an extent that it can't be shared amongst ourselves. So members, feel free to engage on the reports that are before you without fear, favor, nor prejudice. There we are. So we have received the presentation. Let's get to the business of the committee, engaging the presentation, making comments, asking clarity, seeking questions. Over to you, honorable members. Let me take the hands. Honorable Wicklin. Let me get the Dr. Beck. Honorable Makuvela. Honorable Beasley. Honorable Bateman. Honorable Kwankwa. Honorable Zungula. Yeah, I don't. Alan Butle, are there other hands on your side after Honorable?
No, Chair, that's Honorable Zungula is the last hand raised. Thank you.
Okay. If there are other hands, you will raise the hands. Honorable Squad. Okay. As and when other members want to speak, they should raise their hands and we'll allow them to do so. Honorable Wicklin, over to you.
Good morning. Thank you, Chair. Chair, I'm going to try to be sequential based on the report so that everybody can follow. And I particularly would focus on all the disciplinary cases and settlements that has been reached by PIC and employees. If I may start on page 3, just to guide you, Chair. If I may start comment and then follow a question. So the first one I want to check with, in particular in the Mr. Haku matter, both the executive head of legal and head of investment management, there was, and it obviously it drilled down to the report of the investigation. There was a matter that relates to they were drawing a line through the recommended and not recommended parts. But the portion that I'm interested in, Chair, is to have an understanding what did they say when they said that, but they would clearly state that their reservations in writing where they appended their signatures. So that's not clear in this report what actually were their reservations in as far as this matter was concerned. and it's clear to me that based on a technicality only, that this matter has been dispensed of. So that's the first matter that I would like to talk to. Then on page 4, charge 3 and 4, there is a 3.8.3 right at the last paragraph. However, they did recommend in the report that the matter be referred to SAPS for further investigation. So my question to the PIC is, have the matter been actually referred to the SAPS? And was there any outcome out of that matter to confirm their suspicion? I get a sense that that's not been done, but I'm led by the PIC. Further to that, Chair, I am quite concerned. There are 2 reports, investigative reports that were done, and in actual fact, forensic reports. And the first one, and if I just quickly can get to the first matter, is a company called Ramalifo, and their capacity where they said that they prefer to have this matter referred to SAP as they don't have the resources to investigate. It concerns me that a company like PIC, with their credibility and the amount of money that they have to look after, employ a company like Ramalifo that don't have the resources. And what concerns me even further, if I look at the second part, at 3.9, so I'm very well acquainted with the Fundutsi company, which is a well-established and well-known company in the forensic arena, Chair, and I'm sure you know them too, that even they say that they can't provide sufficient evidence to justify the disciplinary action. We are requesting that we possibly could get both these reports to have an understanding why both these companies would say that, and particularly the Fundutsi matter. And then further to that, my question is, how much did these reports cost us, or the PIC? What was the value that was spent to get these reports that led to nothing? Then there was then also an opinion that was raised by the PIC legal counsel, if I go further to 3.10, that gave them 3 options to consider and how they would proceed with this matter. What I'm more interested in is that the PIC legal team considered that they also should then maybe act against all the members of the bid adjudication committee. My question would be then, who sat on those committees, and why was that not considered? I mean, that would have been a much easier option, and then at least they could have had a blanket process going and clear everybody or not clear everybody. I just want to get some clarity on that. Further down, Chair, on page 5, 3.15, and this is so the settlement. So let me maybe just bring you into confidence. I'm sure you do know, Chair, that as the CEO has rightly said, that it was a settlement made for 10,418,107 rand, and then a further 367,000 on the 16 days accrued leave. My concern is, and it lies with, if I take, and the settlement was related, they originally started with a 60-month settlement, which was eventually negotiated down to 21 months salary, and that resulted in the 10 million. If I do the quick calculation, it tells me that this man's average salary was just under 500,000 in a month. Can that be true? If that is so, it is really of concern that this is the type of salaries we are paying people. If somebody can just respond to that. Thank you, Chair. I'll move on to the second matter, which is the Mr. Moshikara matter. I know that the CEO has referred to that the delegation will be investigated, and my question is, what is the deadline on investigation for the Mr. Moshikara matter, and when can we receive some feedback and how this matter would be going? Chair, if I go further down to page 7, on the matter of Ms. Matebula, she was charged with the distribution of confidential PIC information. Now, I would like to speak to a number of issues. I know that the Commission has made certain recommendations, and what's quite interesting, if I look at, and I want to refer you to page 8, where there are 2 matters that the Party Commission specifically referred to. The one is that in the hearings, they found that she held very strong views on the board deliberation and that she appeared to have been taking sides among board members. So it's very clear from these responses that the board's confidentiality is at great risk, even now as we speak, as she's back in the job. So it should really concern the CEO sitting with a company secretary, whereas apart from her already been found guilty, let's start there, she's still in the same position. And if the board, and here's my bigger concern, is that the board is at great risk in the future, particularly around their credibility, and how can we be certain that their credibility is well taken care of? I also would like to know if the documents that were leaked, if that led to any financial impact or adverse impact to the PIC, because that was not made very clear. I also would like to know further, do board members and those that associate, like for instance, in our case, the secretariat, and their matter, they had the company secretary, do sign confidentiality agreements, and what are the penalties if they are contravened? If there are such a reference, can that also be forwarded to us? And the agreement itself, we would like to know what that agreement looks like, and maybe tighten up the relationship inside the board with regards to that immediate dismissal must be the minimum sanction. And that leads me to the second part, Chair. If the HR policy makes provision for any sanction guidelines for certain transgressions, and you would find the number of, and I just referred to municipalities and I referred to certain SEOs, state SOEs, whereas they got very specific sanction guidelines for chairpersons to make decisions on, and if possibly that could be reviewed. And the CEO knows, as well as I know, that if they consider to proceed with this matter, it will result in double jeopardy. Do you realize that the PIC has actually put himself up for failure and are aware that this double jeopardy might lead to further settlements and payment to this specific employee? And we want to know if that risk, and how did the PIC allow that to happen? Chair, then, without saying anything further on this matter, only accept what the Party Commission refers to and emphasize that this is making a mockery of the PIC's disciplinary process. And I hope the CEO takes heed of that as well. What's my further concern is in page 9, Chair, and possibly if the PIC can tell us, and on 7.3 there was reference made to the board minutes that could not be found on the outcomes of that meeting. And here's my concern. Has the administration been tightened up now? Where are we with this type of, will we in future see, again, this has been an excuse that board minutes cannot be found? I mean, this is totally unacceptable. And then just on 7.5, Chair, on the matter of, so on the 7.5, the CEO already determined that you would have to make a determination, as that has now been referred back to him to make a decision. Could he maybe give us an idea when he suggests that we would get this this report back from him and to the board, so that we can also be acquainted with the feedback? Then I just want to get clarity on, I'm almost done, Chair, is on page 10, on number 8, on the matter of Mr. Rikotso. There was a matter that I referred that he has declared. It's not clear what has he declared. If we can have some feedback on what has he declared and how does this matter tie in with the current investigation against him. And then lastly, on the matter of Mr. Rikotso, can we get some specific timeframes and who was appointed to investigate this matter? Chair, I will leave it at that. I don't want to take up too much time. Thank you, Chair.
Thanks, Honorable Whitley. Dr. Beck.
Thank you, Chairperson. And just before I start with my questions, word of thanks to the parliamentary legal advisors for the clear guidance that these documents are now in fact in the public domain and we can engage with them as needed. My first question relates to the company secretary, and from the information we received, and what is on the public record already, it seems that the PIC now finally agrees that the Party Commission recommendation for the board to reconsider the PIC Company Secretary Bongani Matebula's reappointment was never completed. However, this is not what the PIC told Parliament when we asked about this in the SCOF meeting on the 18th of June this year. And so now I want to know, why did the PIC mislead Parliament? Why did the former chair mislead Parliament? And I want to understand, as the new PIC leadership, are you going to lay a complaint against the former chair, or should we do it? In any event, it's now half a decade later. So I want to know, when can we expect completion of this recommendation? Can you give us a timeline? And for the board to then reconsider Mrs. Matebula's reinstatement? And am I correct that in subsequent years from the Party Commission recommendations, there was another investigation and disciplinary finding against the same person? As it relates to Isabaya, the Isabaya Fund's gross loans as of 30/20/25, how much of it is impaired? This is in the documents you've shared with us. Could you indicate to us what the IRR was in the last decade as opposed to since inception? Could you give it to us for the last 5 years? And can you give it to us for the last 3 years, as well as the last year? I want to understand a bit more about the property loans. What's the total value of direct property loans as of 30 June 2025? How much of that is impaired? Again, this is in the documents, and you should be able to provide this to us today. On to Lansera and Mr. Dlamini. The last time you were in front of this committee, Mr. Dlamini, we asked you who is the shareholder of Lansera who asked you to stand as a director on the board of Lansera Holdings. You said that you did not recall. Have you now had time to consult your records and figure this out for us? And I just want to make sure you understand. I understand what you're saying if you say that you still cannot recall. You were asked to stand as a director on the board of a major airport, and there are only 3 shareholders. But you don't recall who asked you. And to the Deputy Minister, if the CEO is not able to recall, as he says, who asked him out of the 3 shareholders, you would have had to assess a potential conflict of interest. And can you please then indicate to us who the shareholder was that asked him? Then on to the 2023 PIC annual report. I read there about an investment called Temu, not to be confused with Temu with the U, it's TEMO, Temu Investment Partners. And I quote, it's an incubation fund manager, which is a first-time fund manager where the PIC clients are anchor investors and the corporation is able to shape the fund strategy and structure. The PIC invested 500 million rand into this fund, whose strategy and structure it then helped shape. Could you tell us, in unambiguous terms, how much is that fund worth today? Now, I want to know a bit more about Harris fund managers. There were questions about Harris that the PIC said isn't really part of their domain, that it falls under the GEPF. Now, I want to point members of this committee to the PIC's annual report for this year. Specifically page 18, where the PIC says both Harris fund managers and Harris general partners are part of the PIC's group structure. And to that effect, I'm now sharing an image in our group chat that shows involvement here. In the financial statements, and its notes, Harris is listed as an associate. Why is it an associate? And are you still sure you can't answer questions around Harris? Chair, I'll leave my questions there for now, but I have no doubt that we'll need multiple rounds of follow-up based on the answers here.
Thank you, Dr. Beck. Honorable Makuel. Honorable Makuel. Alan, is she still in the platform?
Hello, Chairperson.
Okay. We'll come back to her. Let's take Honorable Beasley.
Yeah, sorry, ma'am, I was on mute. Just greetings to everybody from a warm Durban. Just a couple of questions from my side. Does the PIC have a suspension policy? Because I just note that Mr. Hako was suspended for over 2 years on full pay, and as Mr. Wakeling explained, on a massive salary. And I've just come out of but I'm still involved in the RAF matter, and one of the big issues that they did is there was just unlimited suspension. They had a policy of 6 months maximum suspension, and the thing is, when suspension's on public money, it's easy to drag. If it was private money and people were paying it out of their own pockets, they would make sure that the process is expedited. But when it's public money and somebody else's money, it can just drag on a bit. Mr. Hako was suspended on the 31st of May 2022. A hearing was only held a year later. But the next month, the PIC were advised to enter into a settlement agreement, but they only did that 15 months later. So in this whole time, he was earning a full salary. And so they can just speak about the suspension policy and why did it take so long. And then the major concern would be that the head of unlisted investment is suspended, the head of listed investment is vacant, and the chief investment officer is suspended. Surely those are three of the key members of the team. And how is the PIC able to function with these vacancies? And then with regard to Enable, I think it was the deputy minister or the chair mentioned that fraud has been committed. Can we be told when we can expect people in orange overalls? Because, people don't get put into orange overalls. We're just absolutely wasting our time. There has to be consequences. And then in terms of Daybreak, I can understand the need to save jobs, but when does a point come when you're actually throwing good money away? And ultimately, the responsibility is as asset managers. And is that being considered in quite carefully? Because as I say, when it is somebody else's money, it's easy to disperse. But if it's your own money, so just has that call been made in terms of throwing away good money after bad? And then just lastly, just a comment, a bit of wisdom that I was always given. If you watch the Sense, the rands will look after themselves. And my concern with the PIC is we're not watching the Sense. And as a result of that, it's going to have an impact on the rands, and it's also going to have an impact on corruption, because corruption can sneak in very, very slowly, very silently. And you think, we're still doing well, we're still getting a nice return. But the reality of it, before you know it, the whole organization is corrupt. So my just words of wisdom to the deputy minister and the board and all the employees is watch the Sense, watch the small amounts, and the big amounts will look after themselves. Thank you, Chair.
Thanks, Honorable Beasley. I don't see Makuela there. In the meantime, let's take Honorable Bateman.
Thanks very much, Honourable Chair, and good morning as well to all of my colleagues and everybody else who's on the platform here today, and to the PIC. Chair, special thanks for arranging this meeting, because it's something we've been asking for some time. I know the program has been very, very full this year. I appreciate it. I'm not formally a member of this committee, so I didn't receive the documents in advance because they were marked as confidential. And now, of course, I will read them now that they've been made public. And then I might have other questions that I cannot ask now and that others may not ask. So, Chair, I'd like to request permission, please, to be able to submit these questions via you after this meeting, if that would be permissible. And then my second question is, according to press reports, the board chairperson of Daybreak Foods, Boyane Segura, resigned abruptly in May this year, shortly after demanding and receiving a 625,000 Rand payment in board fees, while the company faced a crisis, including unpaid staff and starving chickens. What has the PIC done about the conduct of this director, and what is the current status of the matter? Thanks very much.
Thanks, Honorable Bateman. Honorable Kwangwa.
Thank you, Chairperson. Let me just open my video briefly to see that I'm not a robot. And then for better bandwidth connectivity, can I just close it quickly, Chair? Thank you. Chairperson, the first thing is that in response to, we are happy to hear that there's a number of investigations that are currently underway with respect, firstly, to the Lanseria deal that we flagged in our complaint and provided specific examples to the PIC and the relevant Department of Finance, so to speak, by extension. However, the Minister made an important point earlier, responding to one of the issues where we were saying that perhaps the EC buyer fund, which is unlisted, should be transferred, say, to other, for a lack of a better word, reputable financial institutions that can deal with it. And we made this due to concerns about weak project evaluation, limited capacity, transparency, and inadequate accountability. I had expected that the PIC's response to address these issues directly. So what concrete steps have they taken to remedy these weaknesses, especially considering that some of the concerns were raised in the party commission report that the PIC shared with us, and we appreciate that a great deal. The Minister also, with respect to the EC buyer fund, mentioned, I think, that the unlisted investment portfolio is at about 4% of the total portfolio. And he was responding specifically to the question about the credit risk management of the unlisted investment portfolio, where we spoke about the credit loss ratio of about 39%. And he explained how it works. He said some of it is historical information, projects that were approved in the past, and how that entire system is structured. What I want to know is that then should the PIC not report historical and current credit loss ratios separately with clear interventions for each period to ensure that all the losses are not aggregated with current figures in a way that conceals the true extent of the present day credit losses, to give a clearer picture in terms of how it reports, to give a clearer picture of what happened in the past, interventions taken in the past, why those credit loss ratios perhaps in the past were as high as they were. I think he highlighted some of the concerns and explained them in detail to separate the two. And we want to know, we're still interested in finding out what was this evaluation methodology which was used in the past, which inflated, the values to that extent. And if you're saying an important, valuer has been, a new valuer has been appointed to try and see what went wrong and what might have been needed to be done differently, then the question would be, how long is that process expected to take place? When should we expect to receive a concrete report about what is then the true value and the true state and what happened insofar as that process is concerned? Because it is our considered view as a party that while we respect the internal processes which are currently underway, that there needs to be a completely independent process. We respect the internal processes and expect that they are going to run their course, but once they are completed, we are of the view that we should invite a completely independent body such as the Office of the Auditor General to do a proper audit of these financial transactions and look into them in their entirety. We raised, for an example, as a concern, the involvement. I think Dr. Berg has actually taken the words out of my mouth. We raised the concern around Herith, and then you said you referred it to GEMS, but we're of the view, and we cited the issue of Patrick Dlamini and Herith General Partners. But at the same time, page 18 indeed mentions your work relationship with Herith. So our view is that there needs to be a complete investigation of the issues we're talking about, including the Moshikara scandal, for example. We're happy to hear that there's also an internal investigation insofar as those allegations are concerned. And indeed, would like to know how long is that process going to take, and when should we expect an outcome, so that we can be able to decide exactly what we would like to do with it. Another question has to do with respect to the unlisted investment portfolio. So how are these valuations structured, and how do you, the deal structuring and exit strategy, so that you are not you're not settled with this project that does not work for years, and you continue to report on it rather, insofar as your credit losses are concerned. How are these done? Are there any external audits now with respect to, in general, other unlisted investment insofar as that is concerned? Honorable Bateman asked the question which I wanted to ask insofar as Daybreak is concerned, and would like to hear what the PIC and the ministers have to say insofar as that is concerned. Thank you for now, Chair.
Thank you, Honorable Kwankwa. Honorable Zungula.
Thank you, Chairperson. Greeting to yourself, the colleagues, and everyone on the platform. I want to also echo the sentiments of Honorable Bateman about the length of the document. And as a person who is not a permanent member of the committee, I would also want to submit that we'll share some of the questions I'm unable to get through now via written format on the document that was sent on number 13, which deals primarily with the issues that were raised by the Deputy Minister. The first question there is trying to understand on the issue with Levoca 805. I want to understand currently what is the status of that issue. The document goes at length explaining about a trigger event, which is an amount that was owed by Levoca to a supplier. I want to understand how much was this amount, and does PIC know if the amount was paid, and also in comparison to how much has Levoca made in the process for the past financial year, because I think it would be interesting to understand the amount that is that deals with the trigger event versus the value that Levoca has brought in terms of the profit that they made, and also whether there has been the amount that brought about the trigger event, whether Levoca has settled it. The other issue, I think a couple of members have spoken about it. It is the issue of Mr. Moshikara, but I also want to add Ms. Lindiwe Dlamini there. I want to understand whether is PIC aware of cases being opened against the two individuals, and what is the status of the two individuals in terms of their employment with the PIC? Have they been suspended? Have they both been working? And what are the reasons for the suspensions for Mr. Moshikara, if indeed he has been suspended? And if that's the case, why would Ms. Lindiwe Dlamini not been suspended as well? Because I'm of the understanding that they both have been, there's two cases that have been opened against both of them. So I want to understand whether PIC is aware of the cases that have been opened against the two individuals, and is it those cases that have led to the suspension of Mr. Moshikara, or how is PIC actually dealing with the cases that have been opened? And also from a PIC side, who would have been responsible for the granting of the 1.4 billion legal indemnity to MetroFibre, which is against Levoca. I'm of the understanding again that the attempt there was to recoup an amount which is less than 1,500. And what is the sequence there? Because I know as well that there are bribe allegations that have been leveled against the staff members of the PIC. So I want to understand the sequence of events. When did the PIC actually take that decision to grant the legal indemnity? Was it before or after the bribe allegations were actually leveled against the staff members of the PIC? And also, I want to understand that when it comes to dealing with the issues concerning the cases opened against the two individuals, besides what the Hawks would do in terms of their own investigations, is the action that will be taken by the PIC to ensure that they do have their own investigation to check from their side what transpired and how they can actually prevent any form of wrongdoing from their side when it comes to their staff members acting outside of the mandate and the ethos of the organization. And also, the last question would be, I think I really want to emphasize the question of the current status of the Levoca PIC transaction, and has any shares been returned to Levoca? And also the issue of the value of the trigger event versus the value that Levoca in terms of their performance as a company that they've brought. Thank you, Chair.
Thanks, Honorable Zungula. Honorable Squat.
Thank you, Chair, and good morning to colleagues and the leadership of PIC. A few questions. I think questions that relate to issues of decisions, quality of decisions, but also disciplinary measures or consequence management has been raised, which clearly show that it looks like there is lack of capacity in terms of dealing with consequence management within PIC, because it looks like cases are started, suspended people, but never get to an ultimate, result in terms of the process that has been started. Secondly, Chair, it's in terms of the lessons that have been learned from the Mpati Commission. Because for me, it doesn't look like we have, in terms of internal controls within PIC, have been able to use the lessons from the Mpati Commission to be able to put the institution or place the institution in a better position when it comes to internal controls. I think I need to really understand as to whether were there any lessons and what is it that has changed after the Mpati Commission that has actually led to strengthening the internal controls within the organization. Chair, the issue of property portfolio investments, I would want to understand as to, because it looks like unless there is a clarity on that one, it looks like the property portfolio asset count has actually declined. However, the value has actually increased, but the count has actually declined. And I would want to understand how PIC is able to dispose the health properties portfolio, but as well as to whether do they dispose it directly to and sell it to developers? And how do they do it in that case if they sell directly to developers? Chair, the issue of unlisted investments. What are there any? Is there any pool that has got potential within PIC in the listed portfolio that has got potential to an extent that it can actually transition to listed? And is there any assistance that is offered in case there is that potential? And if there's any, I think it would be great if we were to be informed as to what extent have we been able to transition unlisted investments to listed. This question that I'm going to be asking, Chair, is related to the investments that are made. As to what spatial impact does it have? Do we have any report where we've been able to measure spatial impact in terms of areas that are underdeveloped, rural provinces, and so on, as opposed to your urban, directed investment? We have any sort of measure that we are able to use to measure that? Because I believe that investment should be able to go in such areas and be able to have that spatial impact, particularly because even those people who are investing in those, or the monies are actually also coming from people who are coming from those underdeveloped areas. In terms of assisting Chair startups, do we have any strategy from PIC that is able to assist startups, particularly in terms of key growth sectors? And if not, what other funding institutions do we work with to look at those areas where we are able to see potential in those growth sectors, but also be able to make sure that we are able to assist the startups to be able to stand on their own? That would relate as well to early stage fund in terms of those startups. Thanks, Chair. I think mine would end there. Thanks.
Thank you. Are you done, Honorable Squad?
Yes, sir. Thank you.
Okay. Honorable Van Rooyen, and then Kaleka Mazibuko. I'm not sure if Makuel is back. She will indicate. Over to you, Honorable Van Rooyen.
Thank you once more, Chair. But also a word of gratitude to the presentation from the PIC. Chair, maybe let me start by indicating our concern as MK Party on the protracted and prolonged processes of dealing with some of these cases. Because these cases have been dragging for quite some time. And as to why we are not registering any conclusion on them, it's a matter of concern to us as MK Party. And of course, as correctly cited by the Deputy Minister, it goes beyond their mandate as PIC, because in most cases they are relying on law enforcement agencies. I think, Chair, maybe as a committee, we should find a way of following up with these law enforcement agents, of course, working with our fellow colleagues in the relevant committees, because we can, I mean, allow this thing to happen as if it's a norm. And it's important for us to collaborate with our colleagues in other committees, more especially those in the security cluster, because the recent revelations that are currently entertained in about the Matlanga Commission and the ad hoc committee of parliament clearly indicated that, that there's something wrong within our security cluster, but not necessarily the security cluster alone, maybe all arms of state, including the judiciary. So it tells that we might need, more especially if we want to see results, because the issues were entertained, I think, as far back as if I'm not mistaken, the 4th parliament. Now we are on the 6th parliament and we are still entertaining the same thing. It's more of a compliance exercise than an exercise with a clear intention of correcting the wrongs of the past. So I think that's one thing that I think as a committee we should consider collaborating with other committees to deal with this mess, because we can't continue talking of the same problem administration after administration. It's not ideal. And secondly, Chair, we appreciate the efforts to ensure that both the IDC, DBSA, and PIC will collaborate to attend to the aspect of unlisted investments. But we are equally concerned that there's no clear plan that will empower us, I mean, to hold the cited entities accountable in terms of executing this particular intention or initiative, which we think is a noble initiative. Because one of the things that we think is affecting the impact of these institutions is lack of collaboration or lack of leveraging, which lead to non-optimization of the provisions that are there for these institutions. So it will be appreciated if maybe your team, DM, give us a report on the progress of this. So it's just one of those undertakings that are not taken serious by affected institutions. Is there any progress that we can look at, or maybe is there any plan of executing this particular initiative? And lastly, Chair, Honorable Beasley asked a very important question around the suspension policy. And this is an important question, Chair, because we seems to be, I don't know, but he made a very good example. If it was our money, we will be acting expeditiously. But just because it's the state money, is the money, I mean, the public funds, we are not acting quickly on some of these suspensions. Now, besides the issue of the existence of a suspension policy, I think we also need to know of the capacity to enforce if that policy is there, that policy, because it doesn't make sense that most of these suspensions are tracked, but also the reasons for them, for some of these suspensions, are so dubious that they are dragged at the end of the day, they are settlements. So you don't even know what was the intention of some of these suspensions in the first place. And that's why there will forever be suspicions around the motives behind these suspensions. In some cases, people are victimized through these suspensions. in some cases, people are just being removed, so a certain decision can be taken in their absence. It's a common fact. We have seen how the matter of the ducats or transaction was dealt at SAA, where the DG was suspended for a wrong decision to be taken. Fortunately, sanity prevailed at the end of that, and the transaction was reversed. But the lesson that we must take from that failed ducats or transaction is that some of these suspensions are done with dubious intention. They are not objective. They are very subjective, you know. So I think we should be asking this question to the DM in your team. Is there any capacity? Because we are taking forever to process some of these suspension, and it's happening at the cost of the public funds. I mean, at the cost of the state. So if there is a problem of capacity, let's know. And I know you always hide behind the complexity of some of this investigation, which at times is also questionable, you know. Thank you, Chair. Those are my few questions.
Thank you, Honorable Van Rijn. Honorable Galega. Mazibu. Okay. She has raised her hand before. Honorable Makovela. Okay. Maybe they will come back. Let's go back to PIC. Dr. Masondo, the CEO, over to you.
Thanks, Chair. May I ask the CEO and his team to start? CEO, over to you.
Thank you, Honorable Chair and honorable members of the committee. I think, starting with Mr. Wakeling's on SACCO and sub-referral matters regarding the SACCO. Yes, this matter was referred to the law enforcement authorities, and as we speak, they are still looking into the matters, and they are handling this matter. And I guess it's all these matters, Honorable Chair, that have been referred to law enforcement authority. Yes, they try to keep us posted in terms of how they are going, but I think it's also quite key to note that they then are now with the Ministry of Police. I think, Honorable Chair, it might be maybe best to also then maybe ask for their progress. It would be easier for Parliament to get, I think, the direct response on all these matters that have been referred to law enforcement authorities, maybe to come from the Ministry of Police, because the best we can do is to refer these matters to them and to give whatever evidence we have and whatever information we have, and they come back to us for further information. We further share that information, but that's about how far we can go. I think the rest with the Ministry of Police and the law enforcement authority systems. And yes, in terms of the reports from the Fundutsi and the Ramulifu, Chair, we will definitely then work on making these reports available as requested. We had earlier on. And again, the settlement amount of 21 months, I think it was the function of negotiations between the parties involved, and that number being arrived at within the approved limit, as my predecessor had been authorized by the board to engage within the 24-month settlement limit, and he came back at 21 months, and it was settled as such. I don't know how much more I can be able to share in that regard, Honorable Chair, in that is what actually happened, and that's what finally prevailed with that agreement that was signed between the parties. But as for Mr. Mushikara, definitely the timeline is that we are moving on this matter because the report has just been finalized and handed over to us. So we are now acting on the report. I can assure the committee through your Honorable Chair that these matters, all the suspensions actually that are currently in place within the PIC are going to be settled or attended to and resolved as soon as possible. We are not going to have people on suspensions forever because that in itself is a waste, because it says you are paying someone who's not offering any value to the organization. Yes, it is in terms of the law, but we cannot afford to have people on permanent suspensions. It is completely unacceptable. The board has made it very clear to us in the organization, and we shall make sure that we waste no time and that we make sure that the matters are taken to their logical conclusion as soon as possible. That's the undertaking we give into the board. And I take, Honorable Chair, that this won't be the last time we're appearing before this committee, and we will make sure that we keep the committee posted on the progress on all these matters. But I can assure the honorable members of the committee, Honorable Chair, that we are definitely paying attention to them, and we will be making sure that these matters are taken to their logical conclusion as soon as possible. And yes, as for our company secretary, yes, the charges were laid, decision taken. The board has asked me to look into this matter and report back to them as recent as last week. It's a matter that actually I am looking into, and really keeping in mind all the various ramifications and implications, but I am guided on this matter. As Honorable Wakeling did say, that there will always be issues and risk of double jeopardy. We would look at this matter properly and make sure that we can then be able to fully report back to the board. As soon as that is done, we will be able to communicate in the next, I'm sure in our next engagement with the committee in this regard. But it is a matter that we will definitely look into and conclude as soon as possible. As for our CIO, who's on precautionary suspension, as well as I said, in terms of the head of this that vacancy and the candidates, he did confirm that he knew some of those candidates, but that has got nothing to do with his suspension as such. But in terms of the investigating team looking into this matter, is PricewaterhouseCoopers and Coopers. I think Mr. Berg actually asked again about the COSEC and the possibility that there was some misleading of Parliament by previous board or by PIC in this case, and who will lay the charge, or must you lay the charge? I don't think we're in a position as the PIC to lay the charge as such. I think if there are charges to be laid, I'm sure those charges will be best placed and positioned within the members of the committee if that is necessary and if that's how they see them. I certainly cannot speak of them or for them as they relate to what happened in the past and what was communicated to Parliament. And I'm not privy to those engagements and communications as such, honorable member. Isibaya Fund, we will definitely look at these matters. I'm sure colleagues, we can give the IRR for the past 5 years, 3 years and 12 months, as well as the impairment for the properties. And as for Lanseria, I was appointed, Honorable Berg, to the board of Lanseria given my previous past and experience in terms of aviation and navigation services, and which were the matters that they were battling with. If you ask me who, I got the letter from Lanseria, but I do suspect that there's a chance that maybe Harris must have been behind my appointment because they felt they needed someone who had specific experience in the aviation sector. And I remember Ms. Matola was the chair at the time of the board. And that is as far as I can take it. There is a good chance, I don't think the appointment came from PIC, no, from Acapulco. So there is a very good chance of that, but I received the letter from Lanseria. So as to who was behind specifically, I certainly still cannot say, but I do suspect it must have been Harris then, because Tepa was the chair of Lanseria at the time. And conflict of interest, Dr. Burke, I still don't understand, because if this conflict of interest you're talking about refers to Acapulco and PIC settlement, I don't think there's any conflict of interest on my part. Acapulco and PIC settled the matter. PIC perfected its security on behalf of GEPF, and Lanseria had nothing whatsoever to do with the perfection of PIC's security in the matter. And Acapulco did not contest that perfection of security as such, and it never came to Lanseria. It's a matter that was between Acapulco and the PIC. And even the settlement now, even the payment of the 411 million rand, it had nothing whatsoever to do with Lanseria, but it was the matter that was independently looked into by the PIC in terms of the independent auditors and the process and the arbitration process. So I don't think if there is any conflict whatsoever insofar as that is concerned. I was not a member of Acapulco. Maybe if I was the member of Acapulco, it could be something else. But it really had nothing to do with Lanseria. This was Acapulco and PIC. And yes, I knew Acapulco from the PIC side, but I don't think I can ever call that a conflict of interest. So I think then it goes on to Temo, the 500 million. Lucky will take us through that one, or like maybe just note, or you want to? Can you come in now?
I can come in later or now.
Okay, come now, so that we then move down the line.
All right, thank you very much, and good morning to the committee. So the current valuation of Temo is about 74 million, but I also think it's quite important to give context. So within private equity or venture capital, when we allocate funds, the fund managers do not draw the full amount. So the 500 million or close to 500 million that we've allocated has not been fully drawn. The fund manager will actually draw the capital as they do their investments. So once they have investments that are ready to go to IC, they will then draw on that capital. And while they have had a very slow start in their deployment, as we speak, they've only done one investment of about 73 million, and this gives them a deployment rate of 15%. Typically, in the second year of deployment, we expect the funds to be sitting at about 30%, but they are tracking rather behind. However, we take confidence or comfort in that. To date, Temo has signed about 8 term sheets, and the value of the deals amount to 386 million. This means then that in 2026, we will start seeing a much faster rate of deployment. And typically, fund managers have about 4 or 5 years to actually deploy capital. So we're thinking that in year 3, they should be on track with their deployment. We have placed them on an enhanced monitoring, where we meet with the CEO about twice a month, and we've got the quarterly advisory board meetings. So we are keeping a close eye on Temo, and we are confident that in year 3, they should then catch up on deployment, and we will then start seeing the valuation also increase in line with the deployment. Thanks, CEO.
Thank you very much, Lucky. IRR numbers.
We'll get those numbers across the portfolios, if we can.
We will submit, Honorable Chair, on the IRR numbers for 5 years, 3 years, and 12.
Lifetime, 10 years, 5 years, and 1 year.
Yes, we will definitely submit those numbers on the Isibaya Fund, Chair, through you, Honorable Chair. As for the Heritage Fund Manager, PIC owns 30% of Heritage. And the PIDIF 1 and PIDIF 2 fund, GEPF did them directly, not through PIC, and that's why we're saying we are unable to engage and to respond on those, because GEPF is directly involved with both the fund PIDIF 1 and PIDIF 2. And as for Mr. Business questions, PIC suspension policy, yes, indeed, as I said, Mr. Arco was suspended for that period on full pay, and the matter was eventually settled. Yes, if you were to ask me if we're happy with someone being on suspension for such a long period of time, definitely, as I said, we really cannot afford to have people being on suspension for way too long a period, and we need to try our utmost best to ensure that the suspensions are as short as possible and matters are resolved as soon as possible. But I guess the HACO matter is what it is, and it happened in the manner that it did. I don't think much could be done in retrospect, but other than to say we take lessons, and we shall make sure that going forward these matters are dealt with much more agile and much more responsibly. And the head of Undistat being on suspension, as well as the CIO being on suspension, I guess here, Honorable Chair and members, there's nothing much we can do. If these allegations are made against our officials, we have a duty and obligation to act on them. And for Mr. Mushikara, it was our counterparty who laid charges and made these allegations. And on the basis of that, we then were obliged to make sure that we then act on these allegations. And he has since provided more information, and we instituted independent investigations. And this report is now with us, and we'll be acting on this matter. And yes, the CIO again is on precautionary suspension. We are busy and we're hard at work on dealing with these matters. And as I said, even this week, with the past 3 days, we've been dealing with this matter together between himself and his lawyers and our lawyers in this case. So we are hoping that we'll be able to come to some logical conclusion as soon as possible. It is receiving our attention in this regard. Yeah, Enable Capital reported the matter to the law enforcement authorities, and they are working on this matter. We've given all the information at our disposal, and they came back and they wanted more information. We provided that information to them, and now the matter is with the law enforcement authorities, Chair. Daybreak, money, good money after bad. I really do believe here, Honorable Chair and Honorable Beasley, that I don't think that Daybreak is good money after bad. because it's something that has got serious potential. We have a gap in our poultry industry. We are importing from outside, and we do have an opportunity for creating job opportunities and sustainable businesses. And I think this one has a very good chance. I think the issue of Daybreak was just an unfortunate mismanagement and criminality that happened, which failed the organization. I think within okay, if it is put under responsible management and people are experienced, and this is something that we do believe that has got a very potential to create more jobs, because you're talking about close to 3,000 employees that really could have gainful employment and sustainable jobs, as we have seen so far, ever since we put that 150 million rand of PIC pick of money. And we do believe that actually that's why we went on this strategic equity partner, that if we get the right people with the right experience and their skin in the game, this business can be able to make South Africa very proud in terms of the kinds of sustainable jobs it can create, as well as filling the gap of poultry in South Africa. And this is actually also the protein that is quite important for the low LSM groups in our society. And really, we just need to make sure that it is responsibly managed and responsibly run, with people who have the experience and also who have the skin their skin in this game. And I have no doubt that this could be really can be a success story, as it has actually started to show us to date, Chair. So yes, I know that the jury is still out there, but if we were to look at the reactivation plan and strategy, it has a very, very good chance of really creating the desperately needed jobs for so many South Africans and supporting so many family members. And yes, I fully agree with you that if we look after the cents, the rents will be able to take care of themselves. And that is exactly what we want to make sure that we do as the PIC and as an asset manager. We really want to convince parliamentarians, the South African public, as well as our clients, that the monies actually that they give to us is really very sacrosanct and treated as such. And we promise to do nothing but that, Chair. And as for Mr. Bateman's question, absolutely, the chair of Daybreak, we absolutely condemn the behavior where you would see the chair of the board paying themselves and the employees and the chicken turning on each other, and the employees going without their salaries. But yes, it is something that we're acting on it, and we're dealing with these matters. It's completely unacceptable behavior and conduct on the side of governance structures. And as for Honorable Ungwangwa, the Lanseria matter, I think it's quite important also to categorically state here that the allegation that I was personally at Mr. Mashwele's house celebrating my appointment to PIC can never be further from the truth. I don't even know, Honorable Chair, where Mr. Mashwele lives. I've never been to his house, not even once. And to say that I was at his house, actually, I was so much looking forward to being given evidence to that effect, because I've never been there and I've never celebrated appointment to PIC, not even with my own family. It becomes such a sad thing, actually, when people can manufacture such allegations just to try and throw something negative at your person. And I must say that it is quite painful an act to observe, and you try to wonder exactly where are people trying to get to and what point are they trying to prove for them to go to that extent. But it is what it is, Chair. We are not going to be derailed, distracted by falsehoods. And it's just like actually trying to respond what the US government is saying about South Africa. I think it's the same thing here, but we are focusing on important things. But I can assure you, Honorable Chair and honorable members, that that has never happened. I've never been there, and I don't know why they decided to make such unfounded allegations. And yeah, Isibaya fund and transfer of such to other DFIs, I think the chair covered that, Honorable Chair, our chair of the board, and definitely concrete steps being taken to sort out governance gaps within the systems. These are the kinds of commitments that we've made, and under the leadership of the board, we want to make sure that all these gaps are really closed, and that the party recommendations are fully put in place, so that we make sure that as the PIC, we focus on managing assets, and we focus on growing these assets for our clients, and that we do not have these kinds of unfortunate incidents happening going forward. We really want to make sure that we really make deep dives into all these issues, and to see what kinds of lessons we can learn out of them, and how do we make sure that going forward we can be able to engage with this committee on improvement and positive things. And in as much as it is 4.5% of the portfolio, but every cent is important, and we want to make sure that we demonstrate responsibility and absolute levels of governance, to make sure that we do what is right and do what our clients expect of us. And it's very important. I'm sure on the valuation methodologies, we will provide more answers on all these matters, but they're independent values, valued every year, and we submit such to our clients for incorporation into their financials. And as Honorable Zungula, we apologize for the length of the documents. I think it was talking to the issues that were raised, and we wanted to provide as much information as we possibly can, because really we want to make sure that we are not seen to be hiding anything from Parliament. You have a duty and obligation to hold us accountable as members of Parliament, and we want to make sure that as a state institution, we do exactly that, and really we would love to do more, because we have committed ourselves to absolute transparency, to ensure that we can be able then to focus the organizations on doing what is expected of it, which is that of optimal asset management and growing the assets of our clients. And again, the Levoca matter, you asked how much they were owing. I think they were owing over 3,000 for the. I will give you now the exact numbers to their lawyers, and there was that issue.
Do you want me to?
Yes. How much exact amount?
Yeah. So Chair, if I may?
Yes.
Good morning.
This is Lindy, our investment legal, Honorable Chair.
Good morning, Honorable Chair and Honorable members. So maybe just a brief background on this transaction. The PIC in February 2024 provided a facility to our counterparty, and security was underpinning this particular facility. And you're quite correct in that there were certain outlined trigger events, which, if occurred, would be tantamount to a breach, which would allow the PIC to accelerate its rights. And one of the acceleration rights was to take ownership of the shares that were pledged in lieu of the loan that was provided. There were several breach letters that were provided to our counterparty in this regard. One was in relation to the non-provision of financial information or management statements, that there was a period of 30 days within which the breach needed to be remedied. And as such, our counterparty failed to remedy the breach. There was also another trigger event which included indebtedness by the company, which was not paid. And despite the grace period that was provided to our counterparty of 20 days to remediate this particular breach, it was not remedied. There were two amounts owing to their respective service providers, which obviously the PIC was not involved in. And once those 20 days lapsed, the PIC then continued to perfect its security in that regard. The other event that occurred was that the entities that we funded were effectively put in business rescue, which that on its own becomes a trigger event, and the PIC subsequently exercised its rights in that regard. The issue of the indebtedness being paid, yes, it was paid, but it was paid circa 7 months after the default notice was issued, and the PIC at that particular instance had already perfected its rights. Where we are now with the process is that there is an ongoing valuation process that is underway, and that is in line with the legal agreements to establish or determine the value. But that process, as I've indicated, is underway and has not yet been finalized. Thank you, Chair.
Thank you. And Chair, allow me to just go back. Honorable Nkoka actually said, what is our exit strategy on unlisted investments? This is an exercise that we are undertaking on all our listed assets because we know that they are distressed and good performing assets in this regard. And we will definitely update the committee as we are dealing with all these matters and as we are making decisions going forward. Chair, and again, there was a question that was asked, is there oh, I'm still coming to that one. But as going again to Honorable Zungula's issues, you also raised has the amount been settled that is owed by Levoca to the, I think they said they have. And then the case that was opened against our employee by the Levoca owner, but he made allegations against both Mushikara that Mr. Mushikara had requested certain products or sunglasses and requested some amounts of monies and visited his house. This is where we looked at, and this matter, as I said, has been finalized, the independent investigation. But as for also Lindiwe in this regard, the allegations are not the same. And there were no corruption allegations leveled against Lindiwe to say there was anything. He never said Lindiwe requested anything from him, nor came to his house, but it was more, he was accusing her of abusing legal against him. That is something that was looked into by the independent investigators. They couldn't find anything to substantiate such, and as a result, there is no further action in that regard. And again, there was no basis for us to look at suspending Lindiwe when actually there was no corruption that was leveled against her, apart from being accused to be abusing law to protect PIC's interest. So that's how we looked at it, Chair. And he was the one who opened the case against Mushikara with the police. And I guess the status shall be given by the minister, through the Minister of Police, by the law enforcement authorities where he opened such cases. I'm not aware of the 1.4 billion to MetroFibre because I'm only aware of the 700 million that we funded him for his 19% shares in MetroFibre. And again, the current status of Levoca is that PIC has perfected its security in this regard, and we have appointed independent valuer auditor to do the valuation of the shares, and we have the draft report now actually from the independent auditors who are valuing the shares. That's where we are at this point in time, Honorable Chair. As for Mr. Sukwati, Honorable Sukwati, we definitely have jacked ourselves up in terms of making sure that we're able to deal with disciplinary measures as well as I don't think we can say we do not have the capacity to manage our disciplinary policy and consequence management, and it is something that we have fully committed ourselves into making sure that it is done properly and that we hold people accountable. And I'm sure the committee will see as we move forward how we deal with such issues, because consequence management is very important. And again, lesson learned from the Empathy Commission, we are the first one to admit that actually we had a lot to learn out of it, and we have put a lot in place in terms of the recommendation to make sure that we do better as an institution and we enhance our governance in this regard. And again, there definitely are some of the assets within the unlisted investment portfolio that have a massive potential of being listed in the stock exchanges. And I'm sure, watch the space, you will see actually some coming through in a not too distant future. And those that do not perform, we definitely are working on them. And as to how are we helping startups, it is something that we are engaging with all the DFIs as well as our our project prep space, and we have our head of that space here, Mr. Lucky Upane, here with us. Lucky, maybe you can come in on that one. We will definitely, will briefly take you through you, Honorable Chair. Lucky.
Thanks, CEO. So as PIC, we have the early stage fund, which seeks to support startups that are seeking to commercialize and to expand. Specifically, the fund seeks to drive innovation, catalyze new and emerging industries, drive job creation, as well as economic growth. And we are deliberate in our funding that would like it to go to historically disadvantaged individuals. This would include youth, women, as well as people living with disabilities. And we mainly work through intermediaries or venture capital fund managers to deploy the capital. And this then enables us to have a much wider reach than if we actually did the deals directly. And I'll speak to that. To date, we've approved transactions amounting to 2.3 billion across 10 transactions. And about 9 of these 10 transactions are fund managers. This means then that PIC has exposure or will have exposure to 90 to 100 startups. And that is the advantage of actually working through intermediaries. And then secondly, because the venture capital space is still nascent in South Africa, the work that we do is actually unlocking a lot of value in the system. In many of these funds, we come in as an anchor investor. And once PIC has come in, you actually find that other institutional investors have an appetite to follow suit. And we are hoping that more and more institutional capital will be going to the space. Not so long ago, we issued an RFP for township and rural intermediaries because we want to actually start funding businesses that are in these areas. So, Chair, that is some of the work that we are doing in this space. Thanks.
Thank you very much, Mr. Pane. Again, through you, Chair, maybe then I can then go on. I mean, on the properties, we had earmarked about 68 properties for disposal. 47 of these have been disposed for a total amount of 920 million rand, which actually equates to average price of just under 20 million per property. And these were done through open tender or auction process. And then I can then get up the issue of rural provinces development impact. And I think it's something that we have to really do the best we can to make sure that we can offer job opportunities and development or impact in our rural provinces and rural areas. And this is something that with our partnership with our DFIs, we can be able to look at and see how best we can be able to play our part to the extent that we can in all these areas, Chair. Then I can come to Mr. Van Rooyen's matters here. His concerns on the protracted processes and people being on suspension for too long. We share in that, and as I said, we are dealing with these matters, and we want to make sure that these do not happen going forward. And our collaboration with DFIs, as I've said, are quite important, and we will, I'm sure very soon you will be able to learn of more initiatives actually that will be executed and implemented, because we are quite aware that we need to do the best that we can to create jobs for our youth and the peoples of South Africa. Our job market has seen a massive bloodbath. That's why I was going much deeper on daybreak and the need for it to be functional and sustainable. And these are the things that we really do not take for granted, Honorable Chair. And that takes me to the end, Honorable Chair and Honorable committee members. I give back to you. I don't know if the Chair of the board wants to come in, but that is it from myself, Honorable Chair. Thank you very much.
No, thanks, Theo. Through you, Chair. On the governance issue, on the extent to which we have improved within the PIC, I think the report that we've attached on the implementation of the party recommendations, it does go at length in laying out what we've done in improving governance, including separating CEO, CIO, because in the past, the two positions were under one person. It generated governance issues. And we continue to look at the extent to which we can also improve in the investment space in terms of the CIO, and the CEO is working on this to just make sure that we further deepen the situation where we've got concentration of power in one person or few people. So there's also work that is going on there, because I think the principle of Mpati, one of the problems that Mpati identified was that you don't need power to be concentrated in one person. And indeed now, the investments are not done by one person. And that's part and parcel of our deepening the recommendations of Mpati. You've got legal, you've got risk, and actually risk. We've also established, in line with Mpati's recommendation, the chief risk officer, who has done a lot of work and is here, August, he's done a lot of work in improving our capacity and internal controls and risk metrics to make sure that we don't have cases where we wait for 10 years and only after 10 years we go to the asset in which we've invested, or to those people that we've loaned some money to say, give us our money back. You know, all the issues that I've also raised in the past around the dividend-dependent loans that depend on companies paying dividend, and that dividend is used to service the loan. So there's a lot of work that has actually happened in that regard. And again, in terms of improving governance, having clear Chinese wall between the listed portfolio, unlisted portfolio. The DOA is quite clear on, and this is also in line with the acts that we've also passed, the FAIZ Act, clear responsibilities there. And that is why, Chair, we're able to hold people accountable for certain things that go wrong within the PIC. And like I said, we may be uncomfortable, uncertain that some people are suspended. It's part of consequence management. And whenever there's vacancies, we get people who act, who meet the requirements, and we continue to build strong capacity within the PIC to strengthen the capacity of the PIC to make a right investment. The last time I mentioned the number of CFAs we have, which is a highly internationally recognized qualification in the world. And some of our, including CAs, they are sought after by other asset managers, not only in South Africa, but everywhere. But it's one thing to be solidly qualified. You also have to act ethically, because you may be technically competent, very good, but if you are ethically challenged, your technical capacity will compromise the organization, will also compromise the money that we manage on behalf of our clients. And I think one of the things that also the committee can help us with here, and it's a point raised by Honorable Van Rooyen, how different committees in Parliament work together to deal with some of the issues, like following up on some of the criminal issues that we're dealing with, reports that we have, things that we've reported to the criminal justice system. And as the CEO has indicated, they do provide continuous update on where we are, or where they are rather. But I do think that the inter-committee collaboration within Parliament will also assist in this regard. Now, the issue of the COSAC, as the CEO has said, we've asked the CEO to handle this matter. Because what has happened is that there was some confusion again, because there was a sense that post-party, the DC took place post-party, and there was some consequence management, and the board did what it did in relation to the company secretary, particularly on the charges related to the leaking of the board information, confidential information. There was an impression that this matter by the board was dealt following the party commission. And then we looked for a record on where this issue is. And unfortunately, we don't have a record that says the matter has been dealt with by the previous board. And that's why we said maybe we need to ask the CEO to look at that matter and look at it holistically in the light of the allegations made, in the light of what the previous board did on the matter, in the light of the fact that there is no record that this matter was dealt with by the previous board post-party. Because like I said, the DC, the previous board always thought that it was dealt with after party, and only to realize that it was only after party recommended that this matter must be dealt with. And when the other board came in, it dealt with the matter from what we were told, but it's very clear that there's no record. So it's a question of where is the record? And if there's no record, how do you basically deal with this matter? The last issue, Chair, is the former Daybreak Chair, Bujane Sohoa. At the time she resigned and got paid, she was indeed owed, like all board members of Daybreak. I think for me, Chair, this was an ethical issue because other board members of Daybreak said, no. Yes, we are owed, but ethically, it does not make sense for us to be paid when workers are not paid, and secondly, when the chickens are starved to death. I think it was an ethical issue on what do you do as a board member faced with a situation where you are owed money, but you've got other vulnerable people and chickens that are starved. Does it make ethical sense for you to be paid at that particular moment? And of course, we take different ethical positions on these issues, and on the legalities, on whether the issue is legal or not. I think she was owed, she got paid. As to the ethics, I think we have different judgments on that. And other board members, as I said, of Daybreak, in my view, they took the right ethical judgment and said, look, we can't be paid under these circumstances. I think that is all, Chair, that's all we can say for now. And by the way, I also thank the guidance on how we should deal with this issue, what we thought is confidential information. Because as we're preparing for this report, Chair, we said it's important for us to be as transparent as possible. And that's how we've always been. Let's give all the information required by Parliament, because that is good for trust, is good for not wasting the Parliament's time in giving information that is incomplete. But the team felt that there's some information that is quite sensitive, and I think maybe through you, CEO, you can come on that part on what were the considerations, on what were the specific issues that necessitated that we consider saying that this document or the report that we're giving to you is strictly confidential. And at that time, it was going to be very difficult for us to consult with the lawyers to get a legal opinion, because we also did not want to delay the submission of this report. So asking for guidance legally on how we should treat this and that information would have delayed the submission of this report. And honestly, we did not want to further delay the submission of this report, because it's when there are these delays that you set in conditions for suspicion, for feeling that there's something that we are hiding. So we were caught in that delicate situation, and we said perhaps the best way is to send the information and indicate that there is some information which is sensitive, and we hope that no one will use this information to the detriment of the PIC and our client. But we'd also like to really thank the legal team from Parliament in providing guidance in this regard. Thank you very much.
Thank you, Dr. Masondo. Are there follow-up questions, members? I saw the hand of Honorable Sandrea.
Thank you, Chair. Thank you, DM, and your team for your responses. There was an undertaking to expeditiously resolve on suspensions that are a concern to this committee. I just wanted to check, Chair, can we get a comprehensive update of all the suspensions that are currently taking place, and of course, an indication of when can we expect them to be logically concluded? Can we get that a comprehensive report? Or maybe if it's there in the document, we can be referred to. I think that will appreciate from an oversight perspective. Thank you, Chair.
Thanks, Honorable Fandre. Honorable Zungula.
Thank you, Chair. Thank you for the responses from the DM and the team. I asked a question, Chair, about the sequence of events regarding the granting of the legal indemnity, whether the corruption allegations against Mr. Moshikara, did they come first? And then what then followed was the legal indemnity or the actions that were taken by the PIC against Levoca. So I just need an answer on that. Also, maybe try to understand what was the role of Mr. Moshikara in the Levoca transaction, especially after there were allegations. I think it will help for the committee to understand what role was he playing for him to actually be finding himself being accused of what he's been accused of. And then I was not answered as well on the how much was owed by Levoca to the supplier. That was one of the trigger events, as well as what is the value of Levoca in terms of how much they've made. Because I think it's very important for the committee to understand the two, just to to check between the amount that was led to the trigger event, and I'm happy that it was eventually paid. But I think it's very important for comparison purposes to understand how much are we talking about versus the amount that the value and the money that was made by Levoca. And also, one of the answers spoke about the management accounts. Have the management accounts, in fact, have all of the issues that brought about the trigger events eventually now been sorted, meaning the Levoca has complied from their end, from their side, when it comes to the submission of the financials, the payment to suppliers, etc. And lastly, about the valuation, do you have estimate times when it will be concluded? Because my view is to say the companies or investments that are doing well, there needs to be some form of protection that is afforded. And whenever there are differences, I think if there is an amicable solution that is found without having in a case whereby PIC on one side is going to be finding itself in some legal disputes over a company whereby the investments are, the PIC investment is making sense to the institution in the sense that there are no losses, instead there are profits. That's all, Chair. Thank you.
Honorable Zungula. Honorable Whitley.
Thank you, Chair. I'll be succinct. I've got two questions. The first one relates to the original question I asked around utilizing forensic investigation companies that do not come to conclusion on the investigations. And in this first matter, there were two investigations. I asked for the cost of that and what going forward will PIC do to ensure that when they do pay, and particularly companies that are well capacitated, going forward to make sure that we actually do get conclusions on investigations, either good or bad, it doesn't matter. The second matter, I'm coming back to the company secretary matter. There were two parts question. The one was there any financial loss due to the findings against the company secretary to PIC and with the information that she shared? And then the second part to that is, can we get clarity if there is a non-disclosure signed by all board members and secretariat staff? And if so, what is the minimum, if somebody's been found to be contravening the NDA, what is the minimum requirements for them to be dismissed? I think it's critical that we relook at those matters. Thank you, Chair.
Thank you, Honorable Whitley. Honorable Bateman.
Thanks very much. Thanks very much, Chair. So just picking up the question on the actions of the board chairperson of Daybreak Foods, the CEO said that her actions were completely unacceptable and that it is being dealt with. If I got the exact words incorrect, but it sounded like that it's being dealt with, or words to that effect. The chair said that her actions were actually legal. So it sounded like the chair was defending her actions. So I'm getting mixed messages around this. So my question is firstly for the CEO, what does the CEO mean when he says that it's completely unacceptable and that it is being dealt with? What does being dealt with mean, or whatever it was, the exact words that he used? Or is it more an expression of it will be dealt with? And from the chair's point of view, was the company insolvent when the fees were paid? And if so, isn't that a breach of the Companies Act to pay one creditor and not when, for example, the salaries have not been paid of many of the employees? And also, isn't it also a conflict of interest for a director to insist on her own remuneration being paid when she's the director of the company and at the same time their employees have not been paid? And particularly given that, if I remember correctly from the media reports, she actually overruled one of the existing directors to make sure that the payment was pushed through. So again, I circle back to the question, what has been done and what is being done? Because one of the big issues that we have with the PIC is that when directors of the companies that they invest in don't fulfill their duties properly, there's no accountability. So is there going to be accountability in this situation? What has been done? Unfortunately, if the PIC wants to regain trust, it needs to be proven with actions, not just the expression of good intentions. Then secondly, on that trust issue, trust requires transparency, and we're not getting transparency still. Imparti made recommendations that various matters needed to be handed over to law enforcement. The problem is we haven't seen any proof that law enforcement is doing anything. So it's impossible to see where has the ball been dropped on this, because there haven't been any prosecutions. I think there were 2 prosecutions perhaps, but those were also VBS directors. So we've been asking repeatedly of the PIC, tell us, if you did refer these matters to law enforcement, who did you refer it to? What are the case numbers? What's been done? Or if you took the decision not to refer, what were the reasons? Why did you not refer it? Until we have some transparency around the enforcement actions of the Imparti Commission, I don't see why this board of directors should deserve the trust of the public to look after public funds. And also on the unlisted investments, I put in these questions, written questions from Parliament, which should be answered within 10 days, 2 weeks, something like that is the rule. I said on the 20th of June, please provide a complete list of the Isibaya investments held by the PIC for the GEPF, disclosing for each investment its cost, the date of investment, the most recent valuation, the date of the most recent valuation, the compound annual return on the investment up to the date of valuation, as well as the aggregated annual rate of return on the Isibaya portfolio as a whole, for each of those over the last 1, 2, 3, 5, and 10 years. That has still not been provided, and we're now in December. In July, on the 4th of July, I asked, please provide a complete list of the Isibaya investments, disclosing for each investment its underlying beneficial owners, whether those are natural persons or listed entities, as recommended by Imparti, to make potential financial crime significantly more difficult and ensure transparent exposure of which individuals are benefiting from PIC support. Again, the question was asked in July. There's been no disclosure. So if this board is continuing to cover up for all of the wrong that's been done in the name of the PIC, the question I want to ask is, why should we trust these directors? Thank you very much, Chair.
Thanks, Honorable Bateman. Honorable Beck.
Thank you, Chairperson. First of all, to the board chair, given that your written responses yesterday indicated you cannot find the board meeting minutes which indicate that you've reconsidered the secretary dismissal issue. Can you answer now with a clear yes or no whether you still believe all the party recommendations have been implemented? To the CEO, you didn't give us a date of when we can expect the company secretary issue to be resolved. Can we have that date? Also, can we have confirmation that later than the party commission recommendations, whether the company secretary was disciplined on a separate matter? You haven't answered these questions, and I've already asked them. So now I'm going to ask them again. I'm going to insist that you answer them, and we'll ask them again. On the Lancera issue to the CEO, I appreciate that you say you were appointed given your experience, but you're now confirming it was Harith that appointed you. And the question was, is there the perception or the potential of a conflict of interest, given that you suspect, as you say, that Harith appointed you to Lancera? You see, I'm sure the PIC fund holders want their CEO to be 100% committed to the best interest of the PIC. So I'll give you an example. Is it not the case that there are now new deals that the PIC and Harith are engaging in regarding FlySAF Air? Let's read into the record your answer to us yesterday. The PIC is currently conducting a due diligence on a potential investment in FlySAF Air, which also involves Harith as one of the parties. The PIC is currently conducting a due diligence, and it goes on about an independent valuation and the like. So I want to ask hypothetically to the CEO, what happens if in 2 years we look back again like we did on Lancera and say Harith did exceptionally well off the back of a weird valuation, as was the case potentially with Acapulco, while the PIC was left holding the bag? I also want to ask regarding Harith being an associate. The PIC owns 30% or more of many companies. Why is Harith an associate in your report? Why is this one an associate? And then to quantify the huge losses in Isabaya and the property loans, I'll now read into the record your response from yesterday. The PIC's total Isabaya gross loans as of 30 June 2025 stands at 69.1 billion, with 35.5 billion of the Isabaya portfolio being impaired, resulting in an impairment ratio of 51.5%. See Annexure C, it says. Likewise, with the PIC's unlisted direct property gross loans as of 30 June 2025, this stood at 10.9 billion, with 3.74 billion of the loan book being impaired, resulting in an annual credit loss ratio of 34.1%, which is an increase of 5.8% year to date from a credit loss ratio of 28.3%. Can the CEO please comment, and the board chair for that matter, on these massive losses? Chair, I'll pause there for now, wait for the responses and see if a follow-up is needed.
Okay, thank you, Honorable Bateman. I don't see any other hand on the platform. Dr. Masondo, CEO, back to you.
Thanks, Chair. CEO, will you go first, please, with your team?
Thank you, Chair. Thank you, Honorable Chairman of the committee. Starting with Honorable Van Rooyen's, currently we have about 3 suspensions at PIC, and we are working on all of them, and I can assure this committee that these matters will be concluded probably, I think at the very latest, all of them, because we are now going into dead period, given that in South Africa, December and January become dead periods. Otherwise, we would have been able to resolve these matters within the space of 3 months. But I think I can confidently commit into making sure that all these matters should be done before the end of March 2026. But as I said, we are working on them. We are implementing the reports actually that came through. Others are still under investigations. So depending on how long the investigation takes, but as soon as the investigations are done, we will then actually be able to act quite swiftly and decisively on all these matters. And I'm sure in our next engagement, we'll be able to then update the committee as to how we're going and how far we moved and how we resolve some of these issues. Then Honorable Zungula, on the Levoca and indemnity.
Yeah.
I will ask Lindwe to talk on this one.
Thank you, Chair, and good afternoon once again. So, Chair, just a couple of questions, or the continuation questions on this matter. So the first one maybe is just to articulate and explain that when a default event occurs in terms of the legal agreements we enter into with our counterparties, the agreements prescribe the amount of time that you have to remediate the breach. We issued the various breach notices that were related to the management account, the non-payment of service providers, and there was one particular instance where the company was put into business rescue, which in itself is tantamount to a trigger event. So you're quite correct in that the payments were made, but the default notices were issued in December 2024. The notification that we received of payment was in July 2025. And at that point in time, the PIC was well within its rights to exercise its rights to take over the shares. The amounts that were stipulated in the default notices that we issued were two amounts, and those were to his particular creditors. And the first amount was 80,500 rands, and the second amount was 129,673. But the principle that's ascribed in the legal agreements is that if there is any form of indebtedness, it warrants the PIC issuing a default notice and exercising its rights in terms of the legal agreement. Instead of giving our counterparty the prescribed period in the legal agreements of 5 business days, we actually gave the counterparty 20 business days to remediate the default post the issuance of the trigger event. And it was still not remediated, which gave just cause for the PIC to take over its security in that regard. The issue of the business rescue is still a continuing issue and has not been remediated. And in terms of the funding agreements and the security documents, that matter does constitute a trigger or a default event, which has not been corrected or remediated. On the issue of the 1.4 billion indemnity, I'm not aware of an indemnity that was issued by the PIC of 1.4 billion rands, but we can certainly check our records. But in all instances where we pursue litigation or any recovery process, we do not issue any forms of indemnity, but we will have to check and come back formally to the committee. But I'm not aware of a 1.4 billion rand indemnity that was issued, Chair. And then with regards to the management accounts, again, Chair, the default was issued in December 2024. The management accounts were only provided to the PIC in October 2025, which was well outside of the 20-day period that we gave our counterparty to remediate the default. Thank you, Chair, and I hope that answers all the questions on Levoca.
Yeah, I think there was an issue on the valuation. Valuation, we have the draft report right now by the independent auditor on the Levoca valuation, and we will await the final report. I can't tell for sure when that will be done. It is done independently, but we're hoping that it will be soon. And on the...
There was one question pertaining to the timing of I'm assuming it's the timing of when the legal action was taken versus our counterparty's interactions with Mr. Moshikara. I can certainly speak for when the legal action was taken, and the legal action would typically in all instances be taken once the breach notices are issued and our counterparties fail to remediate the breach notices. That is the only instance where we will then initiate the legal action to perfect our security, but it would not happen prior to that. We would give them a reasonable opportunity to remediate the default, failure of which we will exercise our rights in line with the legal agreements. Thank you, Chair.
Thank you very much, Lindiwe. And again, on Honorable Wakeling's forensic company's costs for this investigation, we shall provide the details as soon as possible. We will definitely share with the committee on that one. The financial loss to the PIC as a result of the disclosure of information or the leaking of information by COSEC, we are not aware of any financial loss that has been suffered by the PIC as such. And definitely there are confidentiality requirements on the board on the side of board members as well as COSAC and many of us who serve on the board. We can't be disclosing confidential information and proceedings of the board as such. And it is in this regard that we will try and look at how we close this matter. We will definitely be able to update the committee accordingly so far as that is concerned, because it's a matter that I'm still going to be looking into as tasked by the board, Honorable Chair and Honorable Wakely. So, but it won't be long. It's a matter that actually I will give priority as well to conclude. And Honorable Bateman, the Daybreak, there is current investigation that is underway looking into all these matters that actually happened, including this particular one of the chair and some of the fraudulent activities that happened by some of the executives, and we will definitely be able to report back in terms of what the report says, but we have instituted investigation to see exactly how do we and what needs to be taken against the various individuals implicated. So it has not been finalized as yet, Chair. So we will definitely give update to the committee once that is done. Yes, no, we fully agree that trust requires transparency, and I think it was good to engage even this morning on the impacted report. A lot has been put in place, as the chair said, and the progress by the law enforcement. I certainly cannot. All I can say is that we had a meeting with some of the generals that are looking into this matter, and they did tell us that they're still progressing these matters, they're still gathering evidence. As to how far and how long it's going to take, I will be lying through you, Honorable Chair, as to how far that is going to take. But we sincerely hope that these matters must be brought into the logical conclusion one way or the other. But we have shared all the information in our disposal with the various law enforcements, because here you're talking about the DPCI, and we're talking about the Hawks. We are engaging the various generals, and they're looking, and there are case numbers. Unfortunately, I don't have these case numbers. I will try and see if we can be able to have access to them. Maybe we can then be able to give such case numbers as a report to the committee as requested. And indeed, we want to make sure that we strengthen our governance in our investee companies and the directors that we recommend to go serve in these organizations. We want to make sure that we send people who are honorable and people who will be able to serve in the best interest of these organizations and be able to abide by the good governance code as well as the ethics requirements. We sincerely hope that because we are trying to enhance our systems to ensure that we only appoint and recommend people who have the requisite skill set and who have the honor to serve in such and be able actually to serve the shareholders of these organizations. And really, we hope that these are people who can be able to do the best for these organizations and add value on the governance side at least. And as for Dr. Bjork, the imparted recommendation, I think it was Mr. Bateman. In part of this report, but through your Honorable Chair, he did say that he did not have access to the report as he's not a member of the subcommittee of the parliamentary SCOF. We had provided quite a number of information as he says, but we will definitely make sure that we also forward him all this information as well, and to make sure that he has access to the requested information. We shall do that, Chair. And Dr. Mr. Bateman, you will be able to get this information as requested. And as for Dr. Burke, we will definitely make sure this is the matter. I don't think it will go beyond the end of Feb, because I know that actually things are going, people are going on leaves, but this is the matter that we will make sure that it is resolved before the end of January, and report back to the board Feb meeting. And that is the best I can do in so far as this one is concerned, but it's not something that's going to take forever. Dr. Burke, it's important. The Leah Herit matter, the New Deals Affair Herit, this matter started even way before I joined PIC, and I'm not here to try and drive these matters. I never worked for PIC, Dr. Burke. I don't understand why this strong association is being made between myself and Herit, as if I have worked for Herit. Yes, we serve together with Mr. Markel at the Lanceria board, but and really the SAFE deal that is going through our systems, which is going to be looked at in its own merit and business rationale, and given the underlying economics of it, and the decision is going to be made to see if it can serve the best interests of our clients. And that's how far this thing is going to be. But I do not see any conflict insofar as I'm concerned in this matter. Yes, Herit is an associate company because we have invested 30% into them, and because we invested into them, they are together with the other companies, like the small. What is it? SME fund? SASME. Yeah, SASME fund. They both are classified as that because the PIC has invested its own money into them, and as such, they are classified as associate companies. And on the unlisted. On the unlisted, the impairments and credit loss ratios, Tundra, you want to talk on this one? Is there anything to cover on this one? Yes. I think that Chair covered the length. You want to please go ahead.
Thank you, Chair. Through you, afternoon. So I think the Chair did cover this matter quite in detail. So the report that we have submitted to this PIC does show that the impairment ratio is about 51% as of June. And I think the key to flag here is that you see in that chart, there is a trend of the orange bar, which is the actual loans themselves, which have gone down from 85 billion to about 70 billion as a date. And these are the loans that have been reducing due to largely being repaid and maturing and capturing back to the PIC. What's remaining in the book is now largely a lot of these legacy transactions and loans that the PIC cannot write off or reduce, even though there is no future economic benefit to these particular loans. And what you're seeing is that they are accruing interest at a default rate of interest, which is punitive rate of interest. And this largely inflates the level of impairments. And this trend will continue to go upwards up until we solve the matter with our clients to write-off policy, because we don't issue as much loans as we did in the past in this current date today as PIC. So you get a net reduction of the good loans that are actually paying back. And what remains in the gross loans is the underperforming loans, which are the legacy transactions, which the Chair has said rightly so, date back as far as 2010, even earlier. So you're seeing this upward spike of impaired loans continue to impair, and the gross loans reducing. And by just looking at the ratio, you would then see that there's going to be larger impairments, lower denominators, bigger ratios going up going forward. So these numbers are quite inflated and cannot be compared to anyone else, because in a normal institution you should have an asset cannot be seen as an asset. A loan asset cannot be seen if there's no future economic benefit. It should be written off according to accounting standards. So this is what we're working on closely with our clients to ensure that we actually bring back these numbers to the correct level. And I think there's a good suggestion that was made by Honorable Kwankwa around splitting up the portfolio, which we can actually do. And if you do that, you'll see the numbers are much more comparable to any institution in the developmental mandate perspective. where we actually have much lower impairment credit loss ratios if we do the split of legacy to current book kind of picture. And that's hopefully we can share that, I think, with yourselves quite soon. So I think that's the key thing. And on the property, again, I think on the property impairment ratios, we have, there's quite a concentrated portfolio, which I think the chair mentioned earlier on, that there has been legacy ways of doing deals in the PIC where there's significant large single issue at risk, where there's large amounts of loans given to single counterparties. And in this case, there's been a large loan given to a single counterparty, and that one loan unfortunately defaulted. And that loan is 90% of that number you see for the property default. So actually it's just one counterparty that we have. We only have 2 loans impaired in the property portfolio, to be frank and honest with the committee. And one of it is 90% of the whole impairment ratio for properties. I think that just gives the technical answer to that question. I hope it helps. Thank you.
And to you, Honorable Chair, we can cover on the indemnity, on Honorable Nkwankwa's indemnity.
Thank you, Chair, and apologies for the confusion earlier on. So, Chair, the letter that we signed as part of the perfection process, it was a letter agreement between ourselves and MetroFibre, and that was instructing them to transfer the shares. And obviously MetroFibre, because they are not part of the lending agreement or arrangement between ourselves and our counterparty, they needed assurances that when they transfer the shares, the information that's provided to the PIC is correct in pursuit of the transfer request that we issued. So there is a standard provision in this letter that talks to providing warranties and indemnities that we will not hold them liable for this process that they are implementing of transferring the shares, given the fact that they were not party to the loan agreement. And there is no amount specified in this letter of 1.4 billion, but it's really to just give assurances that our instruction for the shares to be transferred, it's in line with the legal agreements, and the position that we're putting to them is true and correct and legally in line with the loan terms. Thank you, Chair.
Thank you, Honorable Chair. I'm not sure if the chair of the board wants to add anything, but we are done on this end. Thank you, Honorable.
Thanks, CEO and the team. There's a question from Honorable Bateman with regard to the payment of the previous chair of Daybreak. I think for me, Chair, there's 2 things. There's a legal and the ethical issue here. And the issue is whether the payment of the former chair was illegal, and Honorable Bateman's contention seemed to be it was illegal because the company was insolvent. My view is that being insolvent does not mean that you can't meet all your financial obligations. Insolvency doesn't mean that you fail to pay everyone. You can be cash insolvent, you can be able to pay some people and fail to pay others. You can pay staff but not be in a position to pay the supplier. I mean, that's my understanding, because if you are insolvent, doesn't mean that because you are insolvent, cash insolvent, you pay workers. Is it illegal because you paid workers what was due for them, and you not prioritize to pay other creditors that you have? Because I don't think being insolvent means that you are not able to pay everyone. And I think for me here, what the previous chair has done wrong, unless it is proven that she forced someone to pay. I mean, obviously that is illegal. But the fact that she prioritized herself in the midst of this crisis, I think it was wrong. Bad judgment. It's something that I don't think that she should have done that. And I'm glad that other board members chose not to be paid under those circumstances. Legally, can we find her legally incorrect? I don't know, unless someone determined that legally it was incorrect for her to have been paid. Yes, if it is proven that she forced someone to pay her, that's again illegal. But the payment itself, minus this allegation associated with the force used for her to be paid, I think legally, I'm not a lawyer, but it will be very interesting to get a legal view, Honorable Bateman, that says that it was illegally in court. There's something illegal in that regard. My ethics, my view, and it was wrong for her to have been paid under these circumstances. And there's a matter that the NSPAS, forgive me for the acronym, so it's an organization, as we all know, it's responsible for the welfare of animals. If they are looking at the matter from a legal point of view, welfare, the welfare of animals, as to whether her non-payment caused what actually happened with regard to the chickens at daybreak. It's a matter that I don't have a strong view in that regard. But I think we do need to separate what is legal and what is ethical. And what is legal is not always what we consider ethical, and vice versa. The issue, the question raised by Honorable Book in the light of the fact that there's no record that confirms that the PIC has dealt with the company secretary's matter, particularly on the way she treated the confidential information. What's my view? Do I think the PIC has implemented all the recommendations of Mpati as per the report we sent to the minister shareholder, the Minister of Finance? I think the previous board had no doubt to doubt the previous CEO in saying that the matter was dealt with in the light of Mpati. I don't think that the board had any reason to doubt the previous CEO insofar as this issue is concerned. And it's a question of the absence of a record, and that's why we've asked the CEO, the current CEO, to advise on this, including engaging the previous CEO on how, in his considered view, this matter was dealt with by the previous board, but we don't have a record to validate that claim. So if indeed there is no evidence and the previous CEO does not really show acceptable evidence that shows that this matter was dealt with, I wouldn't insist, and we as the previous board will not insist that there is 100% implementation of the Mpati recommendations as it relates to what the PIC had to deal with. Because you'll recall that the Mpati recommendations, there were recommendations in relation to the governance of the PIC and other related matters that the PIC had to deal with. And including this particular matter. The report that went to the minister said 100% everything done, but thanks to your persistent questioning on this matter, that we had to go even to our record to validate what the previous CEO has basically assured the board that this matter was basically dealt with. So until there's acceptable evidence that this matter was really dealt with, I wouldn't say the PIC in relation to issue that it had to deal with 100% implementation of the recommendations was done. And that is why when we submitted this report, we expect the shareholder minister to do an audit. And my understanding is that the audit, and subject to correction, the audit, it is being done. And it's also at that time that if the audit proves that there are certain things that we did not 100% implement as the PIC, we will be willing to be corrected. We're not going to fight with facts. If facts are shown that no, on the following things you did not, we will clearly accept that yes, maybe on this one and that one, we did not fully implement the recommendations of Mpati. But so, I mean, that's the context. So that's my answer, Dr. Book, in relation to the issue around the company secretary. And that's why the board, upon recognizing, realizing that there's no record, we asked the CEO to basically deal with this issue and deal with it in its totality. Because as you read the report, the previous board, the reason why, I mean, there was a split over this matter, and I think we've really indicated how the previous board before Mpati dealt with this matter. So I think the CEO has also mentioned that he's not aware of any material loss, financial losses related to the leaking of the information by the company secretary. And I think for me, it's beyond the financial loss. It's also the principle about treating the confidential information of the organization, regardless of the intentions. Because there's proper laws that govern how you deal with whistleblowers, that protect whistleblowers and so on and so on. So, but again, we don't want to run ahead of ourselves. The CEO has been given that mandate on how we should deal with this matter in the light of the fact that there's no record that is on how the board has basically dealt with this matter. It doesn't mean that the matter was not dealt with, and hence the engagement with the previous CEO. And if there's acceptable evidence that the matter has been dealt with, we'll come back to the committee and report the matter accordingly. Thank you.
There is a matter that is raised by Honorable Zungula. I think it's on Levoca. Let me check what he has written here. Okay, you say, amount owed by Levoca to their suppliers. Yeah, is there on the chart? Can you see it?
Yes, Honorable Chair.
Okay.
And
please respond to that.
Yes, Honorable Chair. I think Levoca owes. We extended 700 million rand, about 700 million rand, to fund his 19+% shareholding in MetroFibre, and that actually has somewhat grown with the interest thereon. But I think, again, on this matter, Chair, as I said, that there's a draft report by the independent valuer. We are not at liberty as such to share, because this is still a draft, and all parties are commenting and engaging with the independent valuer in this regard. So it's not a final number until we get the final report. Only then we will know for sure then what is the final value of the MetroFibre is. And I think there was also another question in the chat from Mr. Bateman on other disciplinary cases against the COSAC. Yes, there was that JGL investigations and the relationship between the COSAC and the board member of Daybreak. And these are all the matters that I will take into account in my dealing with this company issues and report back to the board and eventually to the committee as well through you, Chair. So we will definitely be looking into all these matters. Yes, there was a second matter as well on it. Thank you, Chair.
Thank you. Honorable Beck, Honorable Van Rooyen. Dr. Beck, over to you.
Thank you, Chair, and a word of thanks to the Deputy Minister for being frank with us today and indicating that the party recommendations have not, in fact, all been implemented 100%, as he says. Chair, I actually want to clear the air a bit with the CEO. It's not my intention to try and prove a strong association. In fact, I'd much prefer to prove the counter, that there isn't a strong association between himself and Harith. Unfortunately, the answers in the last committee meeting and some of the answers today have been a bit vague and perhaps even feels evasive. So if he wants to, for the record, for us, state that there's in fact no association between himself or any of his associates, and there's never been a direct benefit or indirect benefit to him or any of his associates by Harith or any of its affiliates and associates here or offshore, then we've got that on the record, it's cleared. That would be super helpful. I'd also like to agree with CEO Dlamini that the police is the appropriate body to ask about ongoing investigations. And usually SCOPA would be the requisite or the relevant forum here in Parliament to deal with the police. But they've indicated to us that they don't have the capacity at the moment or for the foreseeable future to do so. And so I want to suggest, with the committee's support, Mr. Chairperson, that we bring the police as well as the NPA's Specialized Commercial Crime Unit before us early next year, before the budget, to update us on where these various matters of investigation are at and what steps they are taking against the individuals involved. And then just the last question to the company secretary, to the CEO Dlamini on the company secretary, which has unfortunately still not been answered, which is he aware, or should we be aware, that there was an investigation and a disciplinary matter relating to the company secretary post the party commission recommendations? Chair, I'll leave it there, and thank you for the colleagues and the content provided today.
Thank you, Dr. Beck. Honorable Van Rooyen.
Well, Chair, maybe one should respond on behalf of MK Party to the suggestion just been made by Dr. Beck. As earlier indicated, Chair, Parliament committees have been doing a lot of work on some of the issues that are presented here, more especially those committees that are in the security cluster. So I don't see anything wrong, because these agencies are a bit stretched, and also our program is very tight at times. I don't see anything wrong through you, Chairperson, if you write on behalf of the committee to those committee specific questions that need to be answered by those entities. Because if we are going to wait for them to appear physically before us, I think it might take us some time. And I'm worried because some of the matters here, and as far as I'm concerned, require our agent attention. So my suggestion is that instead of waiting them to appear physically, through your leadership, Chair, you can engage the chairpersons of the relevant parliamentary committee and source the required information for this committee to continue doing its oversight work. And secondly, Chair, I don't think when I said we need, because our oversight work and responsibility should not wait for their next physical appearance. Hence, I insisted that we need a written comprehensive report on all the suspensions. So as next time when you come here, or even before you come here, we are able to hold you accountable on giving effect, to your undertakings in terms of dealing with these prolonged and protracted suspensions, And I didn't hear you acceding to that, because we really need a comprehensive report. They can be 3, they can be 4, they can be more, but it's important for us to know the details of the status, the progress status of each matter. Of course, there I'm not saying give the details of each, but I'm not saying just update us. How far is this matter? It's being investigated, blah, blah. You can't generalize. Each case, I mean, must be treated on the basis of its merit. Thank you, Chair.
Thank you, Honorable Van Rooyen. Honorable Zungula.
Thank you, Chair. Chair, I've got a problem with how I think my question, it seems as if it's intentionally being misunderstood. I'm not sure whether that it is to avoid answering the question or not, because I think this is the 3rd time I'm asking this question. I asked it in the first round, second round, and then now in the chat group. The initial answer, when I asked about this question, it was that there was an amount that Levoca owed to a supplier, and that amount outstanding led to the trigger event. I then asked, what was that amount which was owed by Levoca to that particular supplier? And I want to believe that they know the amount, because the other question that I asked was whether has the amount been paid, and the answer was yes. So the question was, how much was it? Because I need to understand, Chair, whether the amount that led to the trigger event versus the value of Levoca, does it make sense? If, for example, the amount was 1,125, whereas Levoca is having value that is over 100 million. Therefore, on the basis of such, I think we need to check the rationale of actually punishing Levoca over an amount of 1,125, yet the company is making in excess of 100 million. So that was the question I asked on the chat group, which was not answered. Then the last question on this issue is whether, since everything has been done in terms of, from the side of Levoca, they've remedied everything which was raised, from paying the supplier, from submitting financials, and including the issue of business rescue. It was of the understanding that even the business rescue issue has been sorted. Now, I wanted to understand now, from what is happening with the valuation, is the PIC going to proceed with the disposal of the asset, even though all of the issues that were raised by the PIC have been remedied by Levoca? Thank you.
Thank you. Dr. Masonda, CEO Lami, and the executive can respond to those issues raised by the 3 members.
Thank you. Thank you, Honorable Chair. And I will start with Dr. Burke. I did say, Chair, just before he came in, that yes, there was a second investigation by JGL on his association with one of the board members of Daybreak. So, and I said I would look into all these matters as I've been asked by the board to look at all of them comprehensively and then report back to the board. So that is what is going to happen. And as to my association with Harith, this is very interesting, Chair. I have no interest in Harith, nor in any of its associate companies or that it owns. And I really do not know where Dr. Burke then actually why he feels I have some association. I certainly do not. And as for Mr. Honorable Dr. Van Rooyen, We will definitely give that report on this, Chair, and we will submit as requested. As we said, we want to make sure that we respond fully and respectfully to the committee's question as they put them to us. And to Honorable Zungula, the Levoca suppliers, I'm told, we had 80,000. There was 80,000, and then was 129,000. And there were litigation against Levoca by these suppliers in this respect. That's what actually triggered the PIC to ask Levoca to make good of this and to resolve these matters. And they were given a certain specified period, and we didn't wish to deal with these matters, and they did not actually deal with these matters within that period. And that actually then led to the perfection of security. And I'm not sure there was something else. I think there's something that Mr. Zungula said about
the value of the shares versus the amount outstanding. Yeah.
Okay.
Yeah. So maybe just to add in relation to the amounts owing to the creditors, and maybe to emphasize the point that was not the only trigger event that occurred, but it was one of the 3 trigger events that occurred. And the legal agreements are very clear. They do stipulate that any indebtedness of the company that's not paid when due or within any applicable grace period within 5 business days, and that breach has not been remediated within the stipulated 5 business days from the issuance of the written notice by the PIC, will constitute the breach, and it will put the PIC in a position where it can exercise its rights. So I think the issue of the amount owing from his service providers versus what we are contractually obligated to do in terms of the clauses in the cession and pledge agreement. The PIC had a legal obligation on the counterparty's failure to remediate the breach, to act responsibly and to perfect its security. And that's exactly what the PIC did in perfecting its rights and taking over the shares in lieu of this ongoing breach that was happening. And I think on the issue of the business rescue, that is still ongoing and has not been formally withdrawn. So the breach is still persistent. Thank you, Chair.
I don't think there's anything left, Honorable Chair, for us to respond to, not unless there are other follow-up questions. Thank you very much, Honorable Chair.
Thank you. Honorable Nkwangu.
Chair, not necessarily a follow-up question. I know that it's your responsibility as the chair to thank the PIC and the minister for their submissions. The reason why I've been quiet and not really asking follow-up questions is because some of the allegations that the executive of the PIC are refuting are allegations that say the UDM has evidence to back them up. And we are happy that this is the initial process. Secondly, that there are internal investigations going on. Once we get the outcomes of those processes, we'll then be able to determine whether how we take the process forward, including the recommendation we made that the Office of the Auditor General should get involved. For example, the link between Harith and Mr. Dlamini and whatnot, I know that we have evidence to that effect, and it will be tabled at an appropriate forum. I also wish to appreciate the fact there's a point made about also referring the matter to SCOPA, and that there would be some kind of a joint involvement between SCOF and SCOPA. We are also looking forward to that process, and I wish to thank you for your leadership, Chair.
Thank you. Are there follow-up questions before we wrap up the meeting and give away forward? Dr. Beck.
Not a follow-up question per se, Chair, just emphasizing a message I sent in the chat that, Honourable van Rooyen has indicated that, perhaps we could reach out to the police and the NPA either via Parliament or directly. I support that, and I would suggest that we write to them as a committee requesting responses by the end of January, and which I think is very much enough time. And given whatever the outcome is there, decide to perhaps then ask them to appear in front of this committee or joint committee or something else. So it's a suggestion, and thank you for the time, Chair.
Thank you. I think we're done. Thanks very much, my